Naomi Stone, Christine Jardine and Minerva Wilson.
Helen Morgan.
Carers and Care Workers Bill.
Second reading what day?
Friday the 24th of November.
Friday the 24th of November. Thank you. The clerk will now proceed to read the orders of the day.
Illegal Migration Bill, as amended in Committee of the Whole House, to be considered.
Now.
We begin with Government New Clause 17, with which it will be convenient to consider the other selected new clauses and amendments as listed on the selection paper. I call Ministerial to move Government New Clause 17.
Thank you, Madam Deputy Speaker. And with your permission, can I take this opportunity on behalf of the Home Office to pay tribute to those Border Force officers who have nobly volunteered to serve in Sudan this week to support British nationals and others as they're being processed and swiftly returned to the United Kingdom. The Home Secretary and I want to praise their professionalism and sense of service and duty. Madam Deputy Speaker, before I set out the key government amendments that we've tabled for report, it's worth reminding the House of why the government has brought forward this vital bill. A sovereign state must have control of its own borders. We quite properly have an immigration system that determines who can come to the UK lawfully, whether it's to visit, to study, to work, or for other legitimate reasons. Our immigration and asylum system also makes generous provision to provide sanctuary for people seeking protection. Indeed, we've offered such protection in different ways to nearly 500,000 people since 2015. But the people of this country are rightly frustrated if a self-selected group of individuals can circumvent those controls by paying people smugglers to ferry them across the Channel on a small boat. Why apply to come to this country for employment if you can instead arrive on a small boat, claim asylum, and then, as one of the amendments to the bill today suggests, acquire the right to work here after 12 months? Illegal migration, I will in a moment, but if I can make this opening point. Illegal migration undermines the integrity of our immigration system. It puts an unsustainable pressure on our housing, health, education, and welfare services. And it undermines public confidence in our democratic processes and the rule of law. That's why we want to stop the boats and secure our borders. And this bill is dedicated to that goal. It will send a clear message that if you enter the United Kingdom illegally, you will not be able to build a life here. Instead, you're liable to be detained, and you will be removed either back to your home country, if it's safe to do so, or a safe third country, such as Rwanda. I'll happily give way to the right honourable gentleman.
Asking the House to believe that it would act as a pull factor, that people will come here on the basis of the possibility that we might pass an amendment giving asylum seekers the right to work. Because if that's the Minister's case, even by his standards, it's particularly poor.
It is a pull factor to the UK that individuals can work in the grey economy here. That is a cause of serious concern. And if we were to add an additional pull factor to the UK by enabling people to work more quickly, then I think it would be yet another reason why individuals would choose to come to the country. And it's a point that I'll return to in answer to other questions before us today. But the vast majority, I won't give way at the moment, the vast majority of those individuals coming on small boats are coming from an obvious place of safety in France, with a fully functioning asylum system. So they're choosing to make that additional crossing. They are essentially asylum shoppers, even if they ultimately came from a place of danger. And they're doing that because they believe the United Kingdom is a better place for them to make their claim and to build a future. And so their ability to work is obviously a part of that calculation. And it's something that our Northern European counterparts say frequently. Let me make some progress, and then I'll return to those members who want to intervene. It's important that we get this bill right. I do understand the complexity of the legal and operational challenges that we face. In enacting this legislation, we must be alert to those who will seek to use every possible tactic to thwart and frustrate the operation of the Act. We've seen that with our groundbreaking partnership with Rwanda, and we'll see it again with this bill. So since introduction, we've continued to examine how to make the bill as robust as possible, as well as reflecting on the debates in committee last month. And the government amendments before the House today are a reflection of that further work and consideration. We've repeatedly been clear that as we reduce illegal immigrants coming in small boats and through other forms of clandestine entry, we will free up capacity for more people to come to this country through safe and legal routes. Well, I'll give way to let me give way to the Honourable Lady, because she's been waiting on me.
Capacity. We know from 2021 that 71% of asylum claims were successful. A further 47% were successful on appeal. These are not illegal migration. So why, if these are successful claims, why therefore are we not allowing people to work? Or is he trying to make the whole system illegal when people come in, and thereby reducing our standing and the rule of law?
There's a number of points there. On the question of work, there is a legitimate point of view, as I've said on a number of occasions, that those seeking a determination should have the right to work. We disagree, because we want to reduce the pull factors to the United Kingdom, not add to them. And deterrence, as I've said throughout my time in this role, has to be suffused to every aspect of our approach, and creating a situation where individuals could quickly access the UK labour market is not sensible if we want to reduce those people coming here in the first place. Let me return to safe and legal routes, which I know is an issue. Well, let me make my remarks, then I'll come to the Honourable Gentleman. But this is an issue clearly of interest to many members on both sides of the House. And in particular, I'd like to note and pay tribute to my honourable friend, the member for East Worthing and Shoreham, with whom I've been having a number of significant conversations in recent weeks. He is keen to see early progress on this front. The government accepts the need for greater clarity about the safe and legal routes available to those seeking refuge in the United Kingdom, whilst reiterating the point that it's simply not feasible for this country to accept all those who may seek to come here. That's why I'm happy to commend to the House my honourable friends' new Clause 8 and Amendment 11. These would first require the Home Secretary to lay before Parliament within 6 months of royal assent a report detailing existing and proposed additional safe and legal routes for those in need of protection. We will aim to implement the proposed new routes as soon as practicable, and in any event, by the end of 2024. Secondly, the amendments would require the Home Secretary to commence the consultation on the annual number of people to be admitted through safe and legal routes within 3 months of royal assent. I'll give way to the Honourable Gentleman.
Couldn't answer this earlier, so perhaps the Immigration Minister can. What is the safe and legal route available today to a young person in Sudan who wants to flee the violence there and come to the United Kingdom?
Well, happy to answer the question. We've consistently said that those seeking sanctuary should do so in the first safe country. And with respect to the developing situation in Sudan, the United Nations is operating in most, if not all, of the countries surrounding Sudan. I met last week with the Assistant Commissioner of the UNHCR, in which we discussed exactly this point. And so the best advice clearly would be for individuals to present to the UNHCR. The United Kingdom, like many countries, works closely with the UNHCR, and we already operate safe and legal routes in partnership with them. That safe and legal route is available today, and in fact, to answer directly the Honourable Gentleman, I will give way to the Honourable Lady in a moment. The UK is the 4th largest recipient of any country in the world of individuals through those routes operated by the UNHCR. So his central contention that the UK is somehow not a generous and compassionate country, that we are not working with organisations like the UNHCR in this regard, is factually incorrect. We are working with them closely. In addition to that, we have a family reunion scheme which has enabled more than 50,000 refugees to come to the United Kingdom in recent years and to meet up with their family members who have also sought refuge in the United Kingdom as refugees. And that scheme is available all over the world. And so if the Honourable Gentleman's example was a young person with family in the United Kingdom, that individual could, through the family reunion scheme, come here. In addition to that, the point made in the bill is that we will expand those safe and legal routes over the course of the next 12 months or so, so that even more individuals can make use of them. I'll give way to the Honourable Lady.
For giving way, and I think he's in danger of taking the UNHCR's name in vain, because they've issued a statement which says the UNHCR wishes to clarify that there is no mechanism through which refugees can approach UNHCR with the intention of seeking asylum in the UK. There is no asylum visa or queue for the United Kingdom. Would you like to correct the record?
No, the Honourable Lady may not. Well, with all due respect to the Honourable Lady, I met the Assistant Commissioner of the UNHCR last week and had this conversation directly with her. So whatever she may be quoting on her iPhone, I would prefer to take at face value that I've had the discussion with the Assistant Commissioner. But the point is that the UNHCR selects individuals who have registered with them and who they have given refugee status to go to other countries on existing safe and legal routes. And it is currently their discretion as to who they put in the direction of the United Kingdom. That was a choice when the UK established that scheme, because the then Conservative government took the view, and it's a perfectly legitimate one, that we would offer complete discretion to the United Nations to select those people who they felt were the most vulnerable in the world and help them to come to the UK. We've already opened the conversation with the UN as to how we will establish a new safe and legal route, and there's a range of options as to how we might configure that. Be pleased to give way to my right honourable friend.
I'm grateful to my right honourable friend for giving way. I wonder if I might assist him in this issue on the UNHCR, because I've also seen the quote from the UNHCR. What the UNHCR is saying, as far as I can see, is that somebody cannot just turn up at the UNHCR and say, I want to go have asylum in the United Kingdom. But what the United Kingdom has as an arrangement with UNHCR is that we say to them, we will take a certain number of refugees or asylum seekers, and will they please identify those who are most vulnerable and therefore those who should be coming under our scheme. There's not that incompatibility that's being suggested.
Correct. My friend is absolutely right. And of course, that is a choice by the UK as to how we structure any safe and legal route, whether we work with the United Nations or indeed any other organisation. It's not impossible for the UK to say that we wish to take individuals from particular countries or regions, but the choice, and as I say, I think it was a perfectly valid one in the recent past, was to give that discretion to the experts at the UNHCR rather than to fetter their discretion. I'll give way to...
I'm not right honourable, but anyway, thank you. I'm very, very grateful to the Minister. Can I just take us back to the issue of people in Sudan at the moment, because he referred to brave officials from his department who are out there. What is the advice being given if a family member has children under the age of 18 who may not be properly documented for all sorts of complicated reasons at the moment, given the situation in Sudan? What will they be able to get on an aeroplane? Will they end up having to make some kind of determination when they get to Cyprus? What's going to be the situation?
We've so far been calling individuals and families forwards in order of priority. and those in Sudan should check the Foreign and Commonwealth Office's published advice to see that. There is discretion for Border Force officers where they where British passport holders or those who have leave to enter the United Kingdom present with minors where there is credible evidence that they are their own children, so as to ensure that the family unit, wherever possible, stays together. I think that's the right approach, and we've worked closely with Border Force to ensure that the group of officers that we have in Sudan have the correct guidelines to operate that policy. And to the best of my knowledge today, we've not encountered any issues, but of course we're getting regular updates to ensure that that's functioning properly. I'll give way to the honourable gentleman.
Very grateful to him for giving way. I just wanted to call the attention of the House to another safe and legal route which exists at the moment, which is the community sponsorship arrangement, which was introduced by my right honourable friend, the member for Maidenhead, as Home Secretary, and this enables communities to welcome refugees from around the world. Does he not agree that this is a really good model that we should expand in future?
I do, and I commend that wholeheartedly. I took part in one sense, a successor to that scheme, the Homes for Ukraine scheme, and it was an incredibly rewarding experience for me and my family. And the principle at the heart of that is that it's not purely a matter for the state to provide support, but there are individuals or groups, churches, synagogues, mosques, who might want to come forward to gather support and funding to meet the state halfway and assist those people to come to the UK. That scheme is available. We would like more people to take part in it, and it's exactly the sort of scheme that could be considered alongside the further expansion of safe and legal routes. If I may, I'll make some more progress, but I'd be pleased to revert to the Honourable Lady in a moment. If I can turn to the other issue that my honourable friend, the member for East Worthing and Shoreham, raised in committee, the issue of unaccompanied children. Again, we've listened to the points that he and honourable and right honourable members on both sides of the House have raised. As I've repeatedly said, this is a morally complex issue. There are no simple answers. Each have trade-offs, but our primary concern must be the welfare of children, both here and abroad. We need to ensure that the UK does not become a destination that is specifically targeted by people smugglers specialising in children and families. I'll make a little bit of progress. I'm also acutely concerned that we balance that with the very real safeguarding risks posed by young adults pretending to be children. This is not a theoretical issue, it's one that we see every day, unfortunately. Today, a very large number of young adults do pose as children. In fact, even with our current method of age assessment, around 50% of those people who are assessed are ultimately determined to be adults. And of course, we've seen some very serious and concerning incidents in recent months, few more so than that raised in this House by my honourable friend, the member for Bournemouth West, when one of his constituents, Thomas Roberts, was murdered by an individual who'd entered the UK posing as a minor, and during his time in the UK had both been in education, in the loving care of foster parents, and in other settings in which he was in close proximity to genuine children. I'd happily give way to the Honourable Lady.
The awful case of Thomas Roberts. I have asked him repeatedly why it was not known that the murderer was wanted for murder in Serbia, and why it also wasn't known that he had already been turned down for asylum in another European country. Why did the Border Force, why did the authorities not know that information?
Well, as I said in answer in the adjournment debate that we had in the House on this issue, I have commissioned a review of all of the circumstances surrounding that most serious case so that we can understand the multiple failures that may have happened whilst that individual has been in the United Kingdom and what lessons we need to learn. Separate to that, I have taken further steps to enhance the security checks that are conducted when individuals arrive at the Western Jetfoil and at Manston, aided by the change in the law that I made earlier in the year, so that we have, in extremis, up to 96 hours in which to hold individuals in that setting whilst we're conducting those security checks. I'm working closely with the security services, police and the National Crime Agency in that regard. And if there are other things that we need to do, we will do them. And if there are other databases that we should be arguing for access to, then we will certainly do so, because it's critical that we secure our borders in this regard. Let me make some progress, if I may. We've been clear that the power to remove unaccompanied children would only be exercised in very limited circumstances, principally for the purposes of effecting a family reunion or to return someone to their safe country of origin.
Will you give way on that point?
If I may just finish the paragraph, then I'll come to the Honourable Gentleman. Government Amendment 174 makes this clear on the face of the bill, whilst future-proofing the bill against the risk that the people smugglers will seek to endanger more young lives and break up more families by loading yet more unaccompanied children onto the small boats. I'll give way to the Right Honourable Gentleman.
I'm very grateful to my right honourable friend, and on the face of it, I very much also welcome the Government Amendment 174 on the limitations to the removal of children and the prescription that's put within it. However, he's alluded to the fact that further down in that amendment, it sets out that the Home Secretary can pass regulations to set out any other circumstances at a later date. Is he referring to changes to the way that the people smugglers may operate? Will this be an affirmative procedure in Parliament? And what sort of circumstances does he anticipate we may be dealing with?
Well, what we do know with this situation is that it is a fast-moving one, and that the people smugglers are individuals and businesses that will stop at nothing and stoop to no new low. And so what we want to do is retain a degree of discretion, of course accountable to Parliament, and we would ensure that it is an affirmative procedure, so that this would have to, or at least would be an opportunity for Parliament to debate this should there be concerns with the approach of any future Home Secretary. But let me be clear that the government's position is that we only see today the use of this power being for those two very limited and I think understandable and sensible suggestions. They are two routes that are used today judiciously. We do, although it's very hard to do this, seek to reunify unaccompanied minors with their family members and succeed in a small number of cases. And we do remove minors from the UK back home to safe countries, always making sure that social services or appropriate authorities are awaiting them on their return. Those things happen today, and we want to see that they continue, and if anything, that we take further advantage of them. I'll give way to the Honourable Lady.
Right. I think nobody in this House will disagree that we need to stop the people smugglers, but I worry that the government's focus is too much on the people smugglers rather than the damage that it's caused to vulnerable children who are already traumatized, and the whole process that the government is proposing is re-traumatizing already deeply traumatized young people.
Well, on the broader point, let me reassure her that as a parent, both myself, the Home Secretary and the Prime Minister gave these questions a great deal of thought, and our motivation was the best interests of children. We don't want to see children being put into dinghies and seeing their lives placed in danger. And when you do see that, that is a harrowing experience that lives with you. We have to take these steps to ensure that when we operate, I will give way to the Honourable Lady, when we operationalise the scheme that's at the heart of this bill, the UK isn't then targeted by people smugglers specialising in families and children. I'll give way to the Honourable Lady.
Way. On that question of children, I think everyone is absolutely agreed at the compassionate expression that the Minister has expressed. But in Kent, we do take the majority of the unaccompanied children to look after. Does he agree that the safest place for those children is to be in the care of the French authorities and not on those boats in the first place? And how will this bill assist with that?
The key element at the heart of this bill is deterrence. We want to deter individuals, families or adults from going into these dinghies, putting themselves at the behest of people smugglers. That is the way that we ultimately protect children. If we allow this issue to escalate, as is not the intention, but is the logical conclusion of those who oppose this bill, it will simply see more children placed into these boats, and we have to stop that. That is what we're setting out to do here. I would, as the Honourable Lady raises the point, I would praise the authorities in Kent who have gone above and beyond to support young people. I've recently visited the facilities there. I'll give way to the Honourable Lady, and then I should make more progress.
Does the Minister agree that it's equally harrowing to learn of pregnant women on these boats arriving to the UK? And does he agree that perhaps they should be exempt from the provisions around removals in this bill?
I don't want to see pregnant women placed in a difficult or compromising position. The scheme is structured in such a way that there is a suspensive claim that can be brought where there is serious or irreversible harm, which is in most cases physical harm, which would prevent an individual being placed on a flight either back home to their own country, if it's a safe place to do so, or to a safe third country like Rwanda, and the usual fitness to fly procedures will apply, and so a pregnant woman would not be placed on a flight to Rwanda or elsewhere unless it was safe to do so, and there's long-standing conventions of practice on how we would make that judgment. Let me make some progress, if I may. On the issue of detention of unaccompanied children, I understand the concerns that a number of honourable and right honourable members have raised about the prolonged detention of children without the authority of a court. And I thank those members, including the member for East Worthing and Shoreham, for very constructive engagement with us on this and other matters. As a result of those discussions, we've introduced Government Amendments 134 and 136 to enable a time limit to be placed on the detention of an unaccompanied child where the detention is for the purposes of removal. I acknowledge his and other members' concerns, indeed I share them, and can commit to work with my honourable friend and others, including the Right Honourable Lady for Chelmsford, with whom I've had a number of conversations, to set out the new timescale under which genuine children may be detained for the purposes of removal without the authority of the court, and what appropriate support should be provided within detention, recognising the obligations under the Children's Act, which is an important piece of legislation. I can also confirm to the honourable gentleman and others that it's our intention that children, where there is no age dispute, are not detained for any longer than is absolutely necessary, with particular regard to the risk of absconding and suffering significant harm. I trust these amendments and these commitments will assuage the concerns that were raised at the committee stage by my honourable friend, and he won't feel the need to press his own amendment 138 on this issue. I'll happily give way.
Thank the Minister for giving away. As he said, the amendments 134 and 136 bring in the opportunity to introduce regulations to setting time limits. In past practice, when there's been a contentious issue like this across the House, it's often been the case that the government will bring forward draft regulations before the end of the passage of the bill in both houses. Could he give that assurance that we can see the detail of what the government is thinking?
Minister.
I'm not able to give that assurance today, but I will give that careful consideration and revert to the right honourable gentleman. We need to make sure that we get these careful considerations and, as I said earlier, difficult judgments right, that we learn the lessons from when children have been detained in the recent past. And I know that he is very aware of that, and indeed in his constituency is an immigration removal centre that he's been very involved with in his constituency duties. And we want to make sure that we are only detaining children in the most limited circumstances and in the right forms of accommodation with the correct scrutiny and accountability. And in the further policy development that we intend to do, I have recently spoken with the Children's Commissioner and asked her to assist us and to give us her expert opinion. And I'm very open and keen to work with any member across the House who has expertise to bring to bear to this issue. And if I may turn to the question that was raised in committee stage regarding modern slavery, the Amendment 4, in the name of my right honourable friend, the member for Chingford and Woodford Green, and supported by, amongst others, my right honourable friend, the member for Maidenhead, both of whom are international champions of this issue and played critical roles in establishing the UK as a leading force in modern slavery prevention and the protection of those who've proven to be victims. This issue, this relates to the issue of modern slavery, and it's an issue that's also addressed in the Amendments 12 and 16 from the Right Honourable Member for Normanton, Pontefract and Castleford, and Amendments 73 and 74 from the Member for Glasgow Central. The bill is intended to stop the boats. People are risking their lives by making dangerous crossings, as well as putting unprecedented pressure on our public services. Amending these clauses to create exemptions that could lead to abuse of our modern slavery protections and risk undermining the very purpose of the bill is obviously something that we need to think very carefully about. But I understand, of course, that my right honourable friends from Chingford and Woodford Green and Maidenhead and others, in the preparation of their amendments, have thought in particular about how we can prevent individuals who have been in the UK for a sustained period of time from being exploited by human traffickers, or if they are already being, from being deterred from escaping that modern slavery or raising concerns with civil society or law enforcement bodies. Those are serious issues and ones that I want to take forward with them, listening to their unrivaled expertise through the passage of the bill and seeing if there are ways in which we can address and assuage their concerns. It's for this reason that we will look at what more we can do to provide additional protections to individuals who suffered exploitation in the UK. I would remind my right honourable friends that the modern slavery provisions in the bill are time limited, recognising the exceptional circumstances we currently face in respect of the illegal and dangerous channel crossings. Unless renewed, these provisions will expire 2 years after commencement. They do take advantage of an express provision within the European Convention Against Trafficking that foresaw that there might be circumstances in which there was a sufficient risk to public disorder, a crisis that merited taking this kind of action. The government would argue that we are in that moment now, and for that reason we need to apply this limited exemption. I'll give way to the Honourable first, and then of course I'll revert.
Thank you, Madam Deputy Speaker. The Minister has quite rightly singled out two of my colleagues with flattery to try and help him, but he didn't single me out, so he's going to get it in the neck. What happens, Minister, if a 16-year-old in Moldova is told that she's got a job in a restaurant in Belfast? She's provided with a Romanian passport. She comes across here on an aeroplane with false documents. But when she gets to Belfast, she doesn't get a job. She's put in a terraced house, forced into prostitution. The lock is on the outside of the bedroom. She's effectively repeatedly raped. The police break that ring, rescue her. At the moment, she gets protection. She gets looked after. She's helped in the prosecution. This bill changes that.
And please tell me why. Because this person has been trafficked, not on a small boat, and exploited here. So why can't you accept the bill that's in my right honourable friend's name? Because it seems to me there is no risk, Minister. And I want your bill to succeed, but this is... yes, thank you, Madam Deputy. Sorry.
Minister.
Well, I apologise to my honourable friend for not praising his long-standing interests and the very good conversation that he and I had recently, in which he made exactly the point that he's just raised on the floor of the House. We are concerned about the kind of cases that he raises and about those individuals who are exploited within the United Kingdom. What we are keen to do is to ensure that that is not inadvertently turned into a loophole that would undermine the broader scheme. One of the existing protections within the bill for an individual such as that is the provision that if you are cooperating in a police investigation, then the duty to remove will be suspended. And so if somebody was in exactly the position that he raised, then they should, of course, go to the law enforcement authorities, and at that point the provision in the bill, the safeguard that we put in the bill, would apply, and they wouldn't be removed from the country. I'll give way to... Well, let me go to the right honourable gentleman first.
I'm going to speak to the amendment shortly, I'm sure, and my right honourable friend and others. I just wanted to raise one particular point. He talks about inadvertently. I just wonder how the Government Amendment 95 is inadvertent, in the sense that it gives sweeping powers to the Secretary of State to decide whether somebody is genuinely giving evidence, regardless of police. And then the last clause is puzzling to me, which it says the Secretary of State must have regard to guidance issued by the Secretary of State, which is the same person, I think. And I'm not sure quite how that balances out the desire to be balanced on this. That's all I would do.
Well, that was a...
Minister.
Thank you, Madam Speaker. That provision ensures that where an individual has presented to the authorities and the police may have opened an investigation, the police would then make a submission to the Home Secretary, who would then decide whether it was sufficiently advanced for the provisions in the bill to apply. I think that's a sensible safeguard, but this is exactly the sort of issue on which I'm happy to continue to work with the right honourable gentleman. I'll give way to the right honourable lady.
I'm grateful to my right honourable friend for giving way and picking up the point that my right honourable friend, the member for Chingford and Woodford Green, has made. I think we were all surprised when we saw Amendment 95 coming from the government, because what Amendment 95 says is not that the police can make an application to the Secretary of State in nice order, and so it says they must assume that the person cannot stay in the United Kingdom unless there are compelling circumstances determined initially by the Secretary of State, endorsed by the Secretary of State, that says that person can stay there.
Minister.
Well, that is the procedure that I've just outlined. The police forces would apply to the Secretary of State, who would then make the determination that she just described. So I think that is an important safeguard to ensure that there is rigour placed around the issue. I will make some progress, because this is a short debate, and I think it's important that we enable people to make... well, it was only a few moments ago that members opposite were saying this was too short a debate, although I would gently remind them that in both days of committee stage we ran out of speakers, including on the SNP side. Now, I really should make progress, actually, because I worry that we're going to run out of time. If I can turn next to the question around the removal of individuals. It's always been our intention... sorry, apologies. I was going to say a few words in response to the new clause 15 and to speak to the issue about suspected terrorists. Of course, I welcome the Shadow Home Secretary's belated, albeit limited, endorsement of the duty on the Home Secretary to make arrangements for the removal of persons who enter the UK unlawfully. presumably including removal to Rwanda, that duty applies across the board, save in the case of unaccompanied children. So again, new clause 15 is, in our opinion, unnecessary. Protecting the public is the government's first priority, and the bill includes powers to detain illegal entrants and, where it is necessary, to release a person on immigration bail. There are existing powers to apply terrorism prevention and investigation measures, TPIMs, where appropriate. They give the security service and the police powerful measures to help manage the risk of terrorism. And they're considered, of course, on a case-by-case basis and used as a last resort if prosecution or deportation isn't possible. We therefore judge that new clause 15 doesn't add anything to the provisions of the bill or existing counter-terrorism powers. I have more sympathy for the Amendment 184, which is tabled by my honourable friend, the member for Dover, in that it is seeking to be a constructive contribution to the debate on how we manage the clear risk posed by terrorism. It's already the case that all asylum claims must be declared inadmissible under the bill. This is the case in respect of any human rights claim in respect of a person's home country. Where we're seeking to remove someone to a safe third country, it is right that they should be able to challenge that removal where they face a real risk of serious and irreversible harm, albeit that that is a very limited ground, and the bill provides for that. But we will always seek to effect removal as soon as possible, particularly where somebody poses a real risk of harm to the British public. Should removal be delayed, I can assure my honourable friend that appropriate steps will be taken to ensure that the public is properly protected. But as she is one of the foremost members in this House in tackling issues related to small boat arrivals, of course due to the particular concerns of her constituents in Dover, I'm grateful to her for tabling this amendment and look forward to continuing to work with her as we work through these challenges. A number of other government amendments address the concerns raised at committee stage by, amongst others, my honourable and right honourable friends, the members for Stone, for Devizes, for Middlesbrough South and East Cleveland, and South Holland and the Deepings, who rightly want to ensure that the scheme as provided for in the bill was as robust as possible and not open to exploitation and abuse by those who seek to frustrate removals. Please take it away.
I'd just also like to reciprocate, if I may. In my 39 years in the House, I have to say I haven't had an opportunity of the kind that's been offered by the government on this occasion for a really good, proper, robust but nonetheless effective dialogue on these incredibly important matters, and I wanted to put on record my thanks to the government for that.
Well, I'm very grateful to my honourable friend for those kind words, and we value his expertise and knowledge and commitment on this issue, and I think he has made this bill a better and stronger one, more likely to succeed in our objective, which is to stop the boats and to restore confidence to the public. It's always been our intention that the only claims that would delay removal are the factual suspensive claims and serious harm suspensive claims provided for in the bill. All other legal challenges, whether rights-based claims or otherwise, would be non-suspensive. New clause 22, put forward by my honourable friend, the member for Devizes, makes it crystal clear that not only will any judicial reviews be non-suspensive, but it will also not be open to the courts to grant interim remedies which have the effect of blocking removals pending a substantive decision on a judicial review. And on a similar vein, new clause 24 makes it clear that any legal challenges relating to a decision about a person's age are also non-suspensive. And through new clause 25, we're taking a power to make regulations setting out the circumstances in which it can be assumed that someone who refuses to undergo a scientific age assessment is an adult. I can assure the House that we will only make such regulations once we're satisfied that the scientific models are sufficiently accurate to mean that applying an automatic assumption will be compatible with the ECHR. And on this question, I'd particularly like to thank my right honourable friend, the member for South Holland and the Deepings, who has worked closely with the government to achieve our shared objective. On the issue of interim relief, we're also replacing the marker clause relating to interim measures indicated by the Strasbourg Court. As my right honourable friend, the Home Secretary, indicated at second reading, the Strasbourg Court is itself carrying out a review of the Rule 39 process at the encouragement of a number of member states, including ourselves, and the former Deputy Prime Minister, then the Lord Chancellor, and the current Attorney General have had constructive discussions with the Court about reform, including Rule 39. But we can and should do more. New Clause 26 will confer a discretion on the Home Secretary or any other Minister of the Crown to be exercised personally to suspend the duty to remove a person where an interim measure has been indicated on an individual case. The new clause sets out a non-exhaustive list of considerations that the Minister may have regard to when considering the exercise of such discretion in that case. The Minister will be accountable to Parliament for the exercise of this personal discretion. The Government expects that the Minister will carefully consider the UK's international obligations when deciding whether to disapply the duty. I'll give way to the Honourable Lady.
To him for giving way. It seems to me that new Clause 26 effectively introduces a presumption that the UK Government will breach international law when interim measures are handed down in this respect by the Court. Now, in Strasbourg. Now, the Home Secretary has already said on the face of this bill that she can't certify that it's compatible with the ECHR, but she's declined to give evidence to the Joint Committee on Human Rights in order to assist us in the legislative scrutiny of this bill. Can the Minister explain to the House why the Home Secretary is so reluctant to come to the Joint Committee to justify her admission that this bill is not compatible with the ECHR?
Well,
Minister?
the government believes that the bill is compatible. We believe that there are strong arguments, and of course, there will be legal debate, but if any aspect of the bill were to be challenged, we look forward to defending it robustly. We take our treaty obligations. I won't give way a second time, if I don't mind, to the Honourable Lady, because we've been very clear that we take our treaty obligations seriously. And with respect to the ministerial discretion in this clause, the Home Secretary, or whichever Minister of the State exercised this discretion, would of course take those obligations seriously, and they would judge the individual... I will give way.
Isn't, in fact, my right honourable friend, in effect asking this House to give legislative sanction to at least the possibility that a Minister of the Crown will deliberately disobey the international law obligations of this country? Isn't that really the effect of what is being asked?
Minister.
No, as I've already said, we take our treaty obligations very seriously, and the Minister exercising this discretion would have to do so. And this power or discretion would be exercised highly judiciously, and it would ultimately be judged on the facts and be very fact-dependent. I'm not going to give way to the Honourable Lady. I will give way one last time, but I must make some.
A minister has always got the ability to ignore an indication under Rule 39, because there is no obligation under the Convention for the government to heed them. It is an indication. Why then does it need legislation? If what in fact is not being asked, that this House should approve, quite consciously and deliberately, a deliberate breach of our obligations under the Convention. That is the truth. The Minister could ignore it, and it would be a matter between states. But this provision invites this House to give legislative authority to the Minister doing that if she chooses to do so. Isn't that the position?
Well,
Minister.
my right honourable friend is correct in saying that Rule 39 indications are that, and that there are circumstances in which ministers have chosen not to apply them. A small number, but there are a number. This clause does not mandate a minister to ignore Rule 39 indications. It says clearly to ensure that there is no doubt whatsoever that the minister has the discretion to do so. It gives a non-exhaustive list of reasons that they should consider. And in doing so, clearly, as I've said a number of occasions, they would take their treaty obligations very seriously. Moving on, as I've said, the bill provides for two kinds of suspensive claims and sets out a fair but rigorous timetable for the submission of any claims, their determination by the Home Office and any appeals. It's important that those who receive a removal notice should be able to receive appropriate legal advice to help them to navigate the process. And so new clause 20 accordingly makes provision for legal aid. I trust this amendment at least will be welcomed by the Honourable Member for Glasgow Central, given that it covers similar ground to her own clause 18. The provision of legal aid will reduce the opportunities for challenges and will speed up removals. As regards serious harm suspensive claims, new clause 17 augments the existing provisions in clause 38 of the bill, which enables regulations to be made about the meaning of serious and irreversible harm for the purposes of the bill. We consider it important and indeed helpful to the courts to provide them with guidance as to what does or does not amount to serious and irreversible harm, albeit that ultimately the judgment will be for the upper tribunal to be taken on a case-by-case basis. And new clause 17 also makes it clear that the serious and irreversible harm must be imminent and foreseeable, which aligns to the test in the bill, or aligns the test in the bill much more closely with Strasbourg practice. Amendments 114 and 119 relate to foreign national offenders. In the Nationality and Borders Act 2022, we legislated to disapply certain modern slavery protections to FNOs sentenced to a term of imprisonment of 12 months or more, and to certain other categories of person who present a real risk to public order. These amendments now introduce a statutory presumption that the public order disqualification applies to FNOs given an immediate custodial sentence of any length. Finally, let me address new clauses 19 and 23 and new Schedule 1, which seek to ensure that we have the necessary broader powers to tackle illegal migration. The new schedule confers new powers on immigration officers to search for, seize and retain mobile phones and other electronic devices from illegal migrants, where it appears to an immigration officer that they may contain information relevant to the discharge of their functions, including a criminal investigation. New clause 19 will additionally put beyond doubt that credibility should be damaged where a person who's made an asylum or human rights-based claim refuses to enable access to their mobile phone or fails to produce or destroys identity documents without reasonable excuse. And on this important change in the law, I pay particular tribute to my honourable friend, the member for Newbury, one of the most experienced members of the House in immigration matters, who made this case very strongly. I'm not going to give I'll draw my remarks to a close now. Madam Deputy Speaker, I won't detain the House by detailing the other government amendments. I've summarised these in a letter. I'll give way to the... if members don't mind, I'll give way to the Right Honourable Lady.
I'm very grateful to my right honourable friend for giving way, and I wonder if he could comment on a matter which has literally been brought to my attention while he has been on his feet, which is a message from Greater Manchester Police relating to their programme Challenger, which is the programme they operate for dealing with serious and organised crime. And they have put this urgent update out. As a result of the Nationality and Borders Act 2022, Changes came into effect in February 23, which have had an immediate impact on potential victims. This has seen positive first-stage decisions drop from around 95% of all submissions to 18% of submissions between February 20th and March the 31st. This means that 4 in 5 potential victims are not able to access immediate support from the National Modern Slavery and Human Trafficking Victim Care Providers. Is my right honourable friend as worried about that as I am? And if he is not worried, is it because he feels that the impact of the Nationality and Borders Act is already working? In which case, why does he need modern slavery provisions in this bill?
Well, it's difficult for me to comment on remarks that are read out, which I haven't seen sight of, as frankly she would not have done when she was a Home Office Minister either. But it is, she and I have a disagreement on the impact that modern slavery is currently having on our system. But the evidence to me is very clear that unfortunately, and this was never the intention of the framework that's been created, unfortunately there is significant abuse. And we see that in particular in the number of individuals who are coming forward with modern slavery claims in the detained estate when we're seeking to remove them from the country. These last-minute claims, currently at 70% of individuals, that, I'm afraid, amongst other evidence, does show that we've got a serious problem and we have to take action. I'm going to draw my remarks to a close now because I think all members want to see an opportunity for others to speak. I'm not going to give way. Madam Deputy, I'm not giving way because there's very limited amount of time. Madam Deputy Speaker, I've summarised the other government amendments, which are of more detailed technical nature, in a letter to the Honourable Member for Aberavon and placed a copy in the library of the House and stand ready to address any particular points in the winding up to debate if necessary. For now, Madam Deputy Speaker, I commend all of the government amendments to the House and look forward to the contributions from other honourable members and will respond to as many as I can at the end of the debate.
Serious harm suspensive claims interpretation.
The question is that new clause 17 be read a second time. Shadow Minister Stephen Kinnock.
Well, thank you very much, Madam Deputy Speaker. I'd like to start by associating myself with the comments by the Immigration Minister about the outstanding work that our armed forces have done in Sudan, and I wish all who are there a speedy return home. I want to start by making one thing absolutely clear, Madam Deputy Speaker, and it's a point with which I am sure every member of this House agrees. The dangerous channel crossings must be stopped. These extremely perilous journeys have tragically led to lives being lost, and the only people who benefit from this trade in human misery are the criminal smuggler gangs and people traffickers, who are laughing all the way to the bank at this government's failure to arrest and prosecute them. Labour has a comprehensive and workable 5-point plan which will defeat the people smugglers and fix our broken asylum system. Our plan is expressed through the amendments and new clauses that we have tabled to this bill, and I will speak to these in due course. But, Madam Deputy Speaker, members opposite repeatedly state that they wish to stop the dangerous channel crossings. But the fact is that they are completely and utterly failing to do so. Every single measure that ministers announce turns out to either be an expensive and unworkable headline-chasing gimmick or a policy that succeeds only in making things worse, or indeed both. And in the case of this legislative sham that we're debating today, this bigger backlog bill, it is definitely both. Madam Deputy Speaker, under the Conservatives, the channel crossings have skyrocketed from 299 in 2018 to 46,000 in 2022. And throughout this period, ministers have subjected the country to a seemingly endless stream of nonsensical proposals, which have all been given pride of place on the front pages of the Daily Mail and the Daily Telegraph, only to be swiftly consigned to the dustbin of history where they belong. Madam Deputy Speaker, in order for a deterrent to be effective, it has to be credible. And of course, your credibility is severely diminished every time you fail to follow through on a commitment that you've made. So let's take a quick canter through some of the posturing and empty threats that this shambles of a government has made over the last few years. They told us that the British Coast Guard would be instructed to push back dinghies in the Channel, which would have breached the law of the sea and potentially led to further deaths of refugees and innocent children. Then they said they were going to build a giant wave machine in the English Channel. I mean, I don't know where you'd find a wave machine round here, given that the Conservatives have closed down most of England's swimming pools, although I suppose it's possible the Prime Minister might have a spare one back at his place. And then they said they were going to fly asylum seekers to Ascension Island, 4,000 miles away, and they even fantasised about sending them to Papua New Guinea, which is literally on the other side of the planet. And that brings us to their latest cunning plan. They went to Kigali and they paid £140 million for a press release. And 12 months later, they have managed to send more Home Secretaries to Rwanda than they have asylum seekers. Madam Deputy Speaker, you could be forgiven for finding all of this quite comical. But the fact is that it's deadly serious, because a vast amount of taxpayers' money is being squandered on a profoundly unethical policy that is designed to fail on its own terms. Because even if the Rwanda scheme does get up and running, which the government admits is unlikely to happen until at least March 2024, the Rwandan government has refused to commit to taking more than around 1 or 2% of those who arrive here on small boats. We're talking hundreds of removals rather than the thousands per year that might have a chance of deterring asylum seekers from crossing the Channel. So it will fail to stop the small boat channel crossings, because if you've experienced personal tragedy, fought your way across continents and handed your life savings to a people smuggler so that you can endanger your own life crossing the Channel, then a 1% chance of being sent to Rwanda is simply not going to represent a level of risk that you might be averse to. I will give way.
On the point of the Rwanda scheme, apart from paying £150 million for maybe deporting 200 people, we also, under the agreement, have to take people back from Rwanda as well.
Well, my honourable friend has made a very important point, which I would also use as a prompt to talk about the Israel scheme. So, of course, Israel and Rwanda did a deal. What happened with that scheme? Every single one of the people that were sent from Israel to Rwanda had left Rwanda within a matter of weeks and were on their way back to Europe. So it's a very expensive way of giving people a round trip, and I would not recommend it as a deterrent. And then, just to add to the general sense that the government has lost the plot, we had the bizarre and frankly appalling spectacle of the Home Secretary jetting down to Rwanda with a carefully vetted gaggle of journalists in order to indulge in a photo shoot that was akin to a Visit Rwanda tourist promo. Now, I may have missed something, Madam Deputy Speaker, but I thought the idea was to deter the Channel crossings by using Rwanda as a threat. I'm not quite sure how that tallies with the Home Secretary likening Kigali to the Garden of Eden. 1 minute, Rwanda is the perfect place imaginable to rebuild your life. The next, the threat of getting sent there is being deployed as a deterrent. It's a truly farcical state of affairs. But it's also of central importance to what we're debating today, because the entire bill is predicated on the government being able to remove those who arrive here on small boats to a safe third country. And right now, Rwanda is the only safe third country they've got. So the fact that the Rwanda plan is unworkable, unaffordable, and unethical renders this entire bill unworkable, unaffordable, and unethical. I will give you.
Because this was an issue he raised before, and I raised at the earlier stages of the bill. When the Home Affairs Select Committee went to Calais in January, and we met all the people involved in patrolling the beaches and the local officials, they told us that when the Rwanda scheme was announced, there was a surge in migrants approaching the French authorities because they didn't want to end up on a plane to Rwanda about staying in France. So there was a deterrent effect. The trouble is it hasn't actually started yet, but if it did, it would have an impact, and that's the point.
Well, I thank the Honourable Gentleman for his intervention. I'm not sure I follow the logic of it, because he said there was a deterrent effect, but it hasn't started yet, which suggests to me that there has not been a deterrent effect. And if we look at the numbers, these channel crossings continue to skyrocket. So I think what matters to this House is results and outcomes, and as things stand, there is no evidence whatsoever that it has acted as a deterrent. Madam Deputy Speaker, this bigger backlog bill is rotten to its very core, because it prevents the Home Secretary from considering those who arrive here on small boats as asylum seekers, and instead obliges her to detain and remove them. But there's nowhere to detain them, and there's nowhere to remove them to either. We already have 50,000 asylum seekers in around 400 hotels, costing the taxpayer an eye-watering £6 million every single day. And on average, each asylum seeker is waiting a staggering 450 days for a decision. The backlog now stands at 166,000, more than 8 times larger than when Labour left office in 2010, when it stood at just under 19,000. And incidentally, I'm still waiting for the Prime Minister and the Minister opposite to apologise to the House and correct the record on that point.
I'm very grateful for the Honourable Member giving way. He mentioned detention, and there are a number of amendments that have been tabled for today's report stage around detention. I listened carefully to what the Minister said about unaccompanied children and detaining them, but I also wanted to ask my honourable friend his views about detaining children, families with children and pregnant women. This House has made very clear in the past its view about safeguards being required for detention of vulnerable groups, as I've just described. Does my honourable friend think that we need to think again now about pregnant women and children with families and detention?
Well, I thank my honourable friend for that excellent intervention. I think she's absolutely right to highlight this issue, and she has tabled a compelling amendment on this issue. She's aware that members on both sides fought very hard for these legal limits, as she rightly pointed out. And, you know, when we're talking about the detention of pregnant women, I think removing those limits now and paving the way for vulnerable individuals to be detained individually, it's morally wrong, it's wrong-headed, it's deeply counterproductive, and I have not heard any argument to justify it from ministers. Now new figures reveal that this bigger backlog bill could end up putting an extra 50,000 people into permanent taxpayer-funded accommodation this year, with hotel costs rising to over £13 million a day, which is over £4 billion a year, during a cost of living crisis. And this is because, according to the government's own forecasts, 53,000 who cross on small boats will be classed as inadmissible, but without any prospect of being removed. And what's particularly astonishing is that they made this same mistake last year by including similar inadmissibility provisions in the Nationality and Borders Act. The result, a cost of £400 million to the taxpayer in just 6 months, with only 21 people returned to their country of origin. Madam Deputy Speaker, this bungling government just keeps doubling down on its own incompetence. The more posturing they do, the more small boats we see. The longer they govern, the longer the asylum backlog grows. And the more our constituents will ask themselves, with record-high immigration figures and a record-high asylum backlog, are our borders more or less secure under the Tories?
I thank my friend for giving way. I completely understand why the Minister did not want to give way, despite saying that he would do on this particular issue. But he raises the question of people being in hotels. Does he also agree with me that this government needs to be honest with its own backbenchers about the statutory instruments it tried to slip out at the end of the last session that will remove the licensing laws from places for houses of multiple occupancy for asylum seekers, that will presumably prevent their local authorities from refusing to license those places? It will also have the consequence of meaning that we no longer require places where we're expecting families and pregnant women and small children to live to have fire alarms or smoke alarms or indeed running water. Does he agree with me this government needs to be honest about how awful it wishes to treat asylum seekers and how it's going to avoid local authorities being part of that conversation?
Well, I thank my honourable friend for that powerful intervention, and she's absolutely right. We're talking here about basic standards of decency and humanity, and houses of multiple occupancy need to be properly regulated. They need a basic floor in terms of certification, registration, safety, health and safety, and particularly when we're talking here about families. So she's absolutely right, and I do think that the government would really should consider being more transparent and straightforward on that point. Fortunately, we on these benches do care about secure borders, and we will clear up the mess by delivering a firm, fair and well-managed system that will stop the dangerous channel crossings. Because we know that good government is not about chasing headlines, Madam Deputy Speaker. It's about common sense, hard graft and quiet diplomacy. And these are the qualities that underpin our new clauses and amendments to this bill.
Shadow Minister for giving way. I intervened with the Shadow Minister at committee stage, and I found out that apparently there's a cap, or the Labour Party support a cap for safe and legal routes, which was news to me at the time. Has the Shadow Minister had any time to think about what that cap level would be? But also, bearing in mind how many people would like to try and get to our country, what the approach would be to those who had failed in their application but had still travelled here illegally and got here? Would the any future potential Labour government be open to deporting those individuals?
Well, the cap has to be determined in consultation with local authorities and with Parliament. That is absolutely right. In terms of removals, of course, what you need is a processing system that actually works so that you can get to a decision, and people who are from safe countries that should be removed, they need to be swiftly removed from our country, and those that are genuine asylum seekers should be granted leave to remain so that they can get on with their lives, and we can start to clear up the abject mess that this government has made of our asylum system. The first part of our five-point plan is to repurpose the funds that are currently being wasted on the money-for-nothing Rwanda plan, and to redirect those funds into a new elite cross-border 100-strong police force that will relentlessly pursue the ruthless criminal smuggling gangs upstream. The latest £500 million payment that the British government has made to the French government will be having some effect on reducing the crossings, but the reality is that we will not succeed if we're focusing all our efforts on the hundreds of kilometres of French coastline where resources are bound to be spread very thin. We also need sophisticated operations with the British authorities working with EU member states, Europol, Interpol and Frontex to tackle the gangs upstream. Our new Clause 16 therefore instructs the government to lay before Parliament a framework for a 12-month pilot cooperation agreement with those governments and agencies that can do just that in order to secure the prosecution and conviction of persons involved in facilitating illegal entry to the United Kingdom from neighbouring countries. Turning to new Clause 16, this also incorporates the, new Clause 16, which I was talking to, also incorporates the second part of our plan, securing a returns agreement with the European Union. This is essential. Since the party opposite botched the Brexit negotiations and Britain left the Dublin Convention, which had provided agreements on returns, the number of channel crossings has gone up by an astonishing 2,400%. For every one person crossing the channel in a small boat in 2019, 24 cross now. Madam Deputy Speaker, there are three vitally important points to make with regards to getting a returns deal. First, international challenges require international solutions. Second, we need an agreement with our nearest neighbours, which must include returns. And third, we will only strike a returns deal with the European Union if we bring something into the negotiation. And that should include a proper plan for capped, safe and legal routes for bona fide asylum seekers located in mainland Europe. We suggest that Britain prioritises unaccompanied children with family in the UK, and our new Clause 14 reflects this. So I think the Honourable Gentleman was first. I will come to the Honourable Gentleman.
I just would like the Honourable Gentleman to reflect on the fact that when President Macron made his assertions about returns back to France, actually the European Union the following day said they weren't going to countenance any such proposals. They just simply do not agree for returns, and furthermore, of course, France itself is not a place where people would associate with persecution or threats or irreversible harm. So what is his argument all about?
This is about a negotiation. We clearly have to do a returns deal. It's an important part of the deterrent effect. You don't get a returns deal unless you have something on the table. And that's where we believe there should be a clear link between policies on safe and legal routes as a way of getting a clear position in terms of negotiations with the European Union. The reality is that this is the only deterrent effect that really is going to work. You're dealing with people that have risked their lives, have fought their way across Europe, are prepared to spend their life savings on paying people smugglers to cross the channel. You're not going to deter them unless they know that there's a returns deal in place. And that's one of the reasons why the Dublin Convention worked. It acted as a deterrent. The reason that how else can you explain that the numbers have gone through the roof since we left the Dublin Convention? It's simple.
I'm grateful because this is just nonsense. In the last year that we were covered by the Dublin Convention, before the pandemic struck, we applied to the EU for 8,500 returns under that returns agreement. Only 105 were granted 1.2%. So this is completely nonsense. It didn't work when we were in the EU, and he's now expecting to magic out some agreement which they're not going to give us anyway. So stop misleading the House about those figures.
I find this response bizarre because there's some very simple facts, which are we left the Dublin Convention, and since we left the Dublin Convention, the number of small boat crossings have gone through the roof. It's not rocket science, Madam Deputy Speaker. It's a simple fact of mathematics. And the point is that you cannot solve an international problem without international cooperation. You have to recognise that there is a flow of asylum seekers coming across the European Union. The idea that we just say to the EU, you can take them all and we're not going to take any, is for the birds. It is fantasy politics. And I'm just quite stunned that members opposite don't seem to understand that very simple political fact.
I will. Actually, I remember, if the Right Honourable Member from Maidenhead doesn't mind me mentioning her, when she was Prime Minister, the first letter that she wrote in trying to trigger Article 50 to the European Union said that we wanted to have a security treaty with the European Union. That's what I would dearly love us to have. I think it's one of the great flaws out of how we've left the European Union that we haven't ended up with that. Surely this should be part of that security treaty so that we have better relations with Interpol, with Europol, with Frontex, with all and we have proper sharing of information so that anybody who is arriving in the UK, we know all their details. Isn't that where we need to go?
The Honourable Gentleman is absolutely right. We know from our long period of being in the European Union that in order to get a deal with the European Union, it has to be a quid pro quo. There has to be a negotiation based on a grown-up conversation about the challenge that you need to tackle and how to tackle it. And a security, an all-encompassing security agreement could be a very good way to open that door because, of course, the European Union knows that the United Kingdom is a very important security partner for all sorts of reasons. So I agree with him entirely on that very strategic point that he's made. So while we support Government New Clause 8 on safe and legal routes, we believe that it should be linked to securing a returns deal with the European Union. And as I said, our approach is based on hard graft, common sense and quiet diplomacy. And we would urge the government to start thinking and acting in the same vein. Our third commitment is that Labour will fix the problems with current resettlement programmes. This includes the broken Afghan schemes. And our new Clause 21 instructs the government to report every 3 months on progress or lack of in meeting its own target in terms of supporting those loyal to Britain Afghans who sacrifice so much to protect our service people and to stand up for our liberal values in Afghanistan. All resettlement routes need to, of course, be properly controlled and managed, and they therefore cannot be unlimited, but they do also need to work. Fourthly, Labour's long-term international development strategy will include tackling the root causes of migration upstream through increased humanitarian assistance and greater emphasis on conflict prevention and resolution programmes. This is slightly beyond the focus of this bill, but an important aspect of migration policy and a lesson that needs to be learned from Afghanistan in relation to Sudan, of course, which was mentioned earlier on. If you cut aid and you cut the right kind of aid, you will end up increasing the challenges around the dangerous channel crossings, and you hurt British values and interests. Excuse me. Our comprehensive plan will also fix what is perhaps the Conservatives' most astonishing failure of basic governance, the failure to clear the backlog. It's truly staggering that just 13% of small boat asylum claims are being processed within 5 years. And it's deeply troubling that while around half of the huge 166,000 backlog is down to small boat crossings, another 80,000 has built up organically under the Conservatives since 2010. This is no coincidence. Home Office decision-making has collapsed. In 2013, the Conservatives downgraded asylum decision-makers to junior staff, hired, literally going from a Saturday job 1 minute to making life-or-death decisions the next. No wonder this resulted in worse decisions, often overturned on appeal, and it's deeply troubling that the staff attrition rate in 2022 in these teams stood at an astonishing 46%. And there is little prospect of improvement, Madam Deputy Speaker, given that Home Office statistics published on Monday show that this year the number of decision makers has actually decreased. So let's be clear. The incompetence and indifference of consecutive Home Secretaries since 2010 that have brought the basic functions of government to a grinding halt. And during this cost of living crisis, the British taxpayer is paying the price. Our new Clause 10 therefore sets out how the government should get on with expediting asylum processing for the countries that are listed in the schedule of this bill. If an applicant has no right to asylum in the UK, they should be removed safely and swiftly to the safe country from which they have come, such as Albania. Further to new Clause 10, our new Clause 13 instructs the Home Secretary to publish a report every 3 months on the progress that she's making on clearing the backlog. The backlog crisis is every...
I'm sorry to interrupt the Shadow Minister's flow, and I wholeheartedly support him, as we have time and time again with regard to the criticisms of the government's lack of processing of cases, including the lack of staffing resources. On new Clause 10, where the proposal is for an expedited asylum process, could he reassure me that there'll be no lessening of the legal rights of asylum seekers, no lessening of access to legal representation, and no lessening of the application of international human rights treaties and conventions under this process?
I thank my honourable friend for that intervention, and absolutely the proposal is that there are a number of countries which have very low grant rates, and that must therefore be where we triage and put them into a category where the processing can be expedited. However, all of the processing must be done on an individual case-by-case basis in line with our treaty obligations. You cannot have block definitions of any particular category of asylum seeker, and of course that's one of the main issues around the legality of this bill, and that includes access to legal aid. So I can absolutely reassure him on that point. We have to get the balance right between the efficiency and effectiveness of dealing with the backlog. That has to be based on triaging, on giving much more support and upgrading the staff in the Home Office, but it must also be, excuse me, Madam Deputy Speaker, it must also be underpinned by the provisions that he refers to. And of course, the return on investment for improving the quality of decision-making would be rapid and substantial, because quicker processing means fewer asylum seekers in hotels. Which brings me to our amendments on accommodation for asylum seekers. Bad decisions on the location of accommodation means that the process then slows down due to legal challenges, and the whole system gets even more clogged up. It would be far better to consult local authorities early in the process, and our new Clause 9 instructs the government to do just that. I was rather disappointed by the fact that the Foreign Secretary and the Honourable Member for Dorset, among others, failed to join us in the division lobbies during committee stage when we voted for this equivalent clause. I'm aware that they have pushed back against ham-fisted ministers trying to steamroller them on this matter, and I also note that they've sided with their local Conservative councils against their own government. But they're certainly not the only members on the benches opposite who have urged the Home Office to do better on this point. And of course, all accommodation must be value for money, as our new Clause 11 indicates. We can't keep having private companies making these huge markups at the expense of the taxpayer.
I think the Shadow Minister for giving way. Just say, for instance, this quiet diplomacy wasn't as successful as he hoped, and actually a lot of his returns agreements didn't actually materialise. And actually all of these people who did arrive here illegally actually were green-lighted if the Labour government was ever in charge. Would there ever at any point be any policy whatsoever to deport to a safe third country?
Well, as I've just pointed out, we're proposing, for example, a fast track for people from safe countries. We absolutely are of the view that people whose asylum claims are not successful or legitimate should be as rapidly and safely sent back to their country of origin. So I hope I've understood the point the Honourable Gentleman was making. I'm not quite sure what it was. Madam Deputy Speaker, honourable and right honourable members on both sides of the House have raised concerns about the way in which this bill will undermine our ability to crack down on modern slavery. And we do have to ask why it is that the Prime Minister has taken the attitude towards trafficked women and young girls being sold as sex slaves and so accommodating to terrorists and criminals on the other hand. You just need to look at his tweet of the 7th of March, threatening victims of modern slavery with deportation. It was disgraceful. And now his government's amendments 114 to 116 have made it even harder for victims to come forward. It will be held up by, I'm afraid, the pimps and the traffickers to threaten their victims. Two former independent anti-slavery commissioners, Sarah Thornton and Kevin Hyland, recently warned that this bill will devastate modern slavery protections and it's a gift to criminals. All of us in this House know that this bill is a trafficker's charter. And then just look at the Prime Minister's shocking record on deporting foreign criminals. Astonishingly, 19 terror suspects are living in taxpayer-funded British hotels because the government has failed to remove them. Labour's new Clause 15 places a duty on the Secretary of State to remove suspected terrorists who've entered the country illegally or consider the imposition of terrorism prevention and investigation measures upon them. Deportations of criminals have fallen off a cliff since the Conservatives came to power in 2010. They plummeted by 66% to 5,000 a year before the pandemic and to just 2,100 in 2021. This is an insult to victims, and it again proves what we all know. Labour is tough on crime and tough on the causes of crime, but under the Conservatives, criminals have never had it so good. Madam Deputy Speaker, the Minister for Immigration was appointed to his position as the moderate voice who would curb the more fanatical tendencies of his boss. But that simply has not happened. Instead, it appears that he's either been kidnapped by the hard right of his party, or he's willingly hitched his wagon to them because he thinks that's the way the wind is blowing. But the Minister is not alone, because his friend the Prime Minister also appears to have caved in to the Home Secretary and the Trumpian faction that she leads. He's caved into her by adding government new clauses 22 and 26 to this bill, thereby completely torpedoing his own negotiations with the European Court of Human Rights. It really is quite extraordinary that Conservative Prime Ministers never seem to learn from the fate of their predecessors. The more you appease the extremists, the more they demand. Yeah. The Prime Minister is weak and he's been played. This weakness did for his predecessors, and ultimately it will also do for him. But arguably the most shocking of this whole sorry tale, Madam Deputy Speaker, is this Conservative government's contempt for cash-payer tax. Aside from losing billions to fraudsters during the pandemic, dishing out overpriced contracts to their mates for unusable PPE and crashing the economy to the tune of £30 billion, the government's asylum policies stand out as a prime example of ministers scattering taxpayer money to the four winds and receiving absolutely nothing in return, chasing headlines whilst buying failure. There are so many vitally important questions to be answered. Why, for instance, has the government failed to publish an impact assessment? For example, do ministers have any idea of the increase in detention capacity that will be required because of this bill? The Home Secretary was completely unable to answer this simple question during her car crash of an interview on the radio this morning. And how much will these additional detention places cost? How much will the government pay Rwanda per asylum seeker? And how much will each flight cost? We still don't know the answer to that question 1 year after the £140 million was given. Our constituents deserve to know, as these decisions impact directly on their communities and on the state of our public finances. It's outrageous the government's not providing an iota of information about the impact of a bill with such huge financial and community impact implications. So we're bound to ask, Madam Deputy Speaker, what are they afraid of? If they truly believe that this bill will succeed in achieving its objectives, then surely they would happily have published the impact assessment well before second reading, and they would have been delighted to stand at that dispatch box to defend it. But of course there is another possibility, Madam Deputy Speaker, which is that ministers have not even attempted to assess the impact of this bigger backlog bill because they're utterly terrified of what they would reveal if they did. They're terrified of seeing the cost of their own incompetence. They're horrified by the thought of being transparent because transparency reveals the truth. And the truth is that this bill will just make everything worse. It will boost the profits of the people smugglers. It will add tens of thousands to the backlog. It will add hundreds of millions to the hotel bills. It will tarnish Britain's reputation as a country that upholds the international rules-based order. It will further inflame community frustration and tension, and it will add to the desperate misery of those who are seeking sanctuary from persecution and violence. Now, many honourable members on the benches opposite agree with every word of what I've just said, and I would urge them to support our new clauses and to join us in the no lobby when we vote against this deeply damaging and counterproductive bill this evening. Thank you, Madam Deputy Speaker.
So, we've had some very long opening speeches, and I've got over 20 people wishing to contribute to the debate. That means that if everybody was to get in, everybody would need to be about 6 minutes, if not less. We will prioritise those who have amendments down, but that is just my guidance for the minute, because we've also got the SNP spokesperson to come in. Surrey and Duncan Smith.
Madam Deputy Speaker, I'm grateful. And I speak to the amendment in my name and that of my honourable right honourable friends, Amendment 4, which essentially is about Clause 21. However, since then I've realised that the government has got a new amendment in, which is 95, and I'm afraid that makes quite a lot of what we're trying to achieve with our amendment almost impossible to deliver. But I will go through the purpose of our amendment and then deal with the new amendment by the government. So first of all, a lot of this is shadowed by the already existing Nationality and Borders Act, which we still wait to see what the impact of that is on a lot of this. And there's some clear evidence already that it is tightening up in the areas that the government now wants to tighten up here in this bill when it comes to the cause of those who have been suffering from modern slavery. And therefore, I question the necessity of these issues in here about modern slavery at all, first and foremost. But frankly, I won't want to do too broadband. I want to focus on this quite carefully. The problem is, I think that the government, I hope, may recognise, and my honourable friend mentioned that that was the general direction of his thinking at the moment, and I really hope that is the case, that there are now unintended consequences of what they've tried to do in this bill when it comes to the changes they're making which concerns Clause 21, and without our amendment will damage it. Now, it's interesting that my right honourable friend got up and intervened with some very new evidence that the police are now saying that the effect of this, even though it's not in, is to concern people who might well give evidence that would lead, therefore, to the prosecution and conviction of those who are guilty of trafficking. Can I just say, I think the whole purpose of this at the end of the day is that we get the traffickers, we prosecute them, and we put them inside. That is one of the deterrents about other traffickers doing the business. And I understand the purpose of the bill is to stop the business model of the traffickers. So this fits with that. The problem is, the counterpoint of that is that that Clause 21 seems to move in the opposite direction of that, and actually now is beginning to discourage the idea of those giving evidence. And the two reasons for that is, and it's very important here to remind everybody, because it gets confused, doesn't it, really, that human trafficking is distinct from people smuggling. You know, we tend to blur the edges of this. Human trafficking is about people against their will who are brought to this location, or whilst in the UK, actually then themselves are abused by all the issues that have been talked about earlier on. The reality is it is against their will. They do not wish to do it, and we need the evidence of that categorically. So it's dealing with the trafficking side rather than the people smuggling that I'm really concerned about it. And remember, a majority of the potential victims referred to by the NRM are exploited in the UK, in full or in part, and mostly those are non-UK nationals, but there are UK nationals caught up in that as well. So this is not, the majority of these cases are not relevant to those coming across on the boats. They're here, they've been trafficked, they're here, and they're now involved in modern slavery, and they are prepared possibly to give evidence to the police with that regard. Could be sexual exploitation, could be criminal exploitation. When I was Secretary of State for Work and Pensions, we saw evidence of that with people brought over to state their claims to benefits, and then they would disappear off, trafficked into brothels and various other aspects. So I want to say, importantly, we need to distinguish that between that and the issue of the boats. And so those are likely to have arrived in the UK illegally within the terms of this bill, whether by small boat, lorry, or with a lead of staying through deception such as false documents, including deception by their exploiter. Instead of being given temporary protection in the UK, these victims will now, if 21 exist, and subsequently now 95 as the amendment, these victims will now be subjected to removal and detention under this bill and denied access to the statutory 30-day recovery period of support for modern slavery victims. Victims will be driven even further underground, which is our fear and those who deal with them, by the fear of deportation and trapped in the arms of their abusers. Why would that be the case? The answer to that is very simple. If one looks at the wording, even of 21, we see straight away that the shift in balance is very clear. That is to say that it is in the view of the government and the Secretary of State whether or not they are going to give evidence, or they're giving evidence that's relevant. So that's left to their judgment. And then we get the Government Amendment 95, which I am really concerned about because it shifts the whole rationale in the opposite direction. So instead of there being a judgment about that, even under 21, it's now clear that the premise of everything that the Secretary of State will make as decision-making is now reversed. So this is very clear. The Secretary of State must assume, for the purpose of subsection 3b, which is in clause 21, that it is not necessary for the person to be present in the United Kingdom to provide the cooperation in question unless the Secretary of State considers that there are compelling circumstances which require the person to be present in the United Kingdom for that purpose. And the point I raised earlier on, and in doing that, the Secretary of State must have regard to guidance issued by the Secretary of State. That looks to me like a bit of a closed advice section, which will come up with the same decision at the end of the day. So that is now to be amended into existing clause 21, which we already had concerns about, which our Amendment 4 was to give protections. And our Amendment 4 was to add to section 3, this other element, AA, which is that if the Secretary of State to make the decision, either the relevant exploitation that has taken place in the UK and the individual is exempt. That is critical, but even that now, it seems, becomes a problem because subsequently the reality is the Secretary of State must assume it's not necessary, which makes it even more difficult to exempt them from that position. I raise that point with my right honourable friend at the front bench, and I think it's very important now that we look at this carefully, and it may well be necessary, and I think it will be necessary, the other place to rectify this, because that sends a terrible signal to anybody who has been exploited. They will be told that, by the way, by the traffickers. Don't worry, they're going to kick you out regardless. What's the point of even helping give evidence? Because we'll get you on the other side if you finger us. That's what's going to happen. I give way to the gentleman.
Honourable gentleman for giving way, because despite his best efforts, and I mean he has a model of clarity on this, it's still like trying to knit fog. And doesn't the fact that we're dealing here with an amendment that he has brought, which has subsequently been affected by an amendment to the original bill by the government, illustrate the total inadequacy of trying to deal with a bill like this in this way?
Well, it's a concern because we've got clashing amendments. We know that. That is the point. In a way of this debate, to rectify that, we haven't got a lot of time to do it, so he'll forgive me if I tentatively nod in his direction, but at the same time pursue my own purposes. I'm going to try and keep this quite narrow. I don't want to go wide because there are concerns about other people wishing to speak. So, this amendment of ours, Amendment 4, why is it needed? It's needed because victims of modern slavery experience inhumane torture and abuse. They're deprived of their liberty and their dignity. They are exploited and abused on British soil, whether UK citizens or foreign national. They deserve clearly care to recover, and we can't leave them subject to that exploitation. And the key that I keep coming back to is victims in this category hold the key to the prosecution of the very traffickers that we're after. And I think we shouldn't lose sight of that. And if the inadvertent result of these changes to the bill and the bill itself is that they now are fearful of coming forward to give evidence, partly because the presumption is that they should go and leave the country, and the second part of that is they don't have enough time to feel settled and protected to be able to give that evidence. So the combination of those two things will mean that the police, and I think they know that, and my right honourable friend has quoted from a police statement, that will reduce the prosecutions, that will damage our case, and will act as an opponent, as it were, of the idea of sending the message to traffickers that your game is up. And all the evidence shows that with appropriate, consistent support, more victims engage with investigations and prosecutions, providing the vital information that brings criminals to justice. But support needs to come first to create that stability, because otherwise they will not feel safe. And if they don't feel safe, and if we put ourselves in their situation, we wouldn't give evidence either if we think the next stage that you're going to is you're going to go out and your traffickers will catch you when you leave the country. Your families or whoever's being abused at the same time becomes a problem. So it gets harder to have convictions, and I'm pleased that my right honourable friend on the front bench did accept that there may be consequences. I think we need to go further than the may, but there are consequences as a result of the legislation that exists here. And I don't believe that the government wants to see victims of modern slavery being trafficked. I don't think they want to see this damaging the Modern Slavery Act. I think that there is somehow in the minds of those in the Home Office a genuine dislike of this legislation and a wish to blame it for excesses. But there is no evidence of that. Even when they come over on the boats, only 6% of those who actually claim to be victims of modern slavery, only 6% of them are the result of the numbers coming onto the boat. So first and foremost, it's a case that there isn't a huge, great swell. But the second thing is the Borders Bill that has preceded this has now tightened up on all the elements that they have to bring to show that that is the case. So it's already tighter, and I suspect will lead to even fewer cases already. So the question mark exists. What is the point of putting these elements into this bill? Because they're already coming through in the previous bill, and we still haven't seen the effect of it. So what we are putting at risk here is the prosecution, first and foremost, of all of those traffickers and bringing them to justice for something which is almost certainly not going to happen. And if it did happen, there is plenty of scope for that evidence to come forward, for there to be subsequent to work through statutory instruments if necessary, but I don't believe that will be the case. And the reality is that it is impossible for people, I'm told endlessly that people will come through and give false claims, but let me remind everybody that referrals can only be made by official first responders who suspect the person is a victim, first and foremost. And in 2022, 49% of referrals were made by government agencies. Ironic, isn't it, really, that it was the government themselves that decided they were victims. So this idea that any person can come forward and just suddenly say, I'm a victim and therefore I'm going to get all this time, it's not. The test of evidence is very tough. And I must say also that remember, this amendment of ours is about those who are trafficked and abused here in the UK. So that means the evidence base is almost certainly going to be incredibly strong because it's based around what we know existing here in the UK. I understand it's difficult when people are trafficked from abroad, but here these are people in the UK and their evidence is clear for all of us to see. So under the changes made to the NRM, statutory guidance on 30 January 2023, which is again, we've yet to see the full effects of that, the threshold for a positive reasonable grounds decision has been raised to require objective evidence of exploitation. So again, my question is, this is an unnecessary element of this bill completely because we have yet to see the effect already of the previous act that came through, and I believe that is already having effect, and the police believe that is the case too, which is the other point. So I'm going to complete my comments because others want to speak. I just simply want to say we should proceed with caution when it comes to modern-day slavery. I, for one, am deeply proud of what we did and what my right honourable friend brought through because it deals with those who are victims, people who cannot speak for themselves, that are being used and abused by others. And we were the first country in the world to do it, and others have followed suit. We need to send the right signals about this. And I think the problem with this bill right now is it's unnecessarily now targeting a group of people that are not the problem, themselves will suffer. And ironically, we will fail as a government through the Home Affairs end of it because the police simply won't be able to get those prosecutions. So on every grounds, this is wrong. And I have to say, their new amendment 95 is a disastrous attempt to make it almost impossible for anyone to feel confident in the country before they give evidence. And I really, really ask the government, before we make a decision about whether this is moved, to make it very clear at the end of this debate that they will take this away and they will genuinely look to see what those unintended consequences are now coming together to become and make sure they make that case to us.
SNP spokesperson, Alison Thurs.
Thank you very much, Mr Deputy Speaker. I rise to move the amendment standing in my name and those of my honourable colleagues. And it's interesting following the honourable gentleman for Chingford and Moodford Green, and I hope very much that given the concerns he's outlined about this bill, that he'll be joining us in the lobbies later on, because I don't expect he's going to get the assurances he hopes for from the Minister. This illegal migration bill remains an affront to human decency and to our obligations to our fellow human beings. It rips up hard-won international protections and is in breach of the European Convention on Human Rights, the Refugee Convention, the Council of Europe's Convention on Actions Against Trafficking in Human Beings and the UN Convention on the Rights of the Child. Scotland's Children and Young People's Commissioner has said that the illegal migration bill represents a direct assault on the concept of universality of human rights and the rule of law. Organisations have lined up to condemn it, from the UNHCR, Liberty, Amnesty International, trade unions and medical bodies. It seeks to turn ships' captains and train drivers into border guards, and it creates a subclass of people in immigration limbo forever. This refugee ban bill is based on myths, mistruths and the myopic pursuit of clicks and tabloid headlines. There is no evidence whatsoever to support the wild claims made by the Home Secretary and her acolytes. The bill will not meet its stated aims, but it will cost lives, and it fails to provide safe and legal routes. It will cause, Mr Deputy Speaker, untold suffering. It diminishes the UK in the eyes of the world, and it yanks on the thread that will unravel refugee protections across the world. It delivers people trafficked back into the hands of those who would exploit them. And the Immigration Minister this morning descended yet further in his article in Conservative Home, speaking of those with different lifestyles and values, cannibalising compassion. Mr Deputy Speaker, it's not a dog whistle, it's a foghorn. Yeah, yeah. The process by which this government has brought forward the illegal migration bill is an insult to democracy and to this House. Rushed through without a full committee stage, no evidence sessions, no evidence whatsoever from the government about the things that they have put forward. Swathes of government amendments brought forward today in haste and not yet even an impact assessment, even at this very, very late stage. That is unacceptable, that we are being asked to vote on something without an impact assessment. And my honourable friend for Cumbernauld, South and Kirkcaldy has requested an impact assessment umpteen times in this House and via an FOI request, and nothing has yet been forthcoming. And I know the honourable member for Bristol West has also been tireless in pursuing this for the bill, and it's testament really to this government's dogged evasion of scrutiny and not to their lack of effort that this has been fruitless. Mr Deputy Speaker, we as members of Parliament in this House are guarantors of rights. The SNP's Amendment 45 seeks to hold the UK Government to its international obligations. How utterly bizarre and reprehensible that we even have to put in an amendment to ensure this, and to attempt to have the provisions of the bill line up with convention rights, the Refugee Convention, the European Convention on Action Against Trafficking, the UN Convention on the Rights of the Child, and the UN Convention relating to the status of stateless persons. Anyone reading the UNHCR's legal observations on the illegal migration bill can plainly see how far the UK Government are deviating from international norms. They say the illegal migration bill all but extinguishes the right to claim asylum in the UK, breaches the UK's obligations towards stateless people under international law, would lead to violations of the principle of non-refoulement, denies refugees and stateless people access to their rights under international law, violates Article 31.1 and Article 31.2 of the Refugee Convention and international human rights law, puts at risk the safety and welfare of children, and would increase the pressure on the UK asylum system. What an atrocious mess this government is making. Further to this condemnation from the UNHCR, the Council of Europe's group of experts on action against trafficking in human beings stressed that, if adopted, this bill would run contrary to the United Kingdom's obligations under the Anti-Trafficking Convention to prevent human trafficking and to identify and protect victims of trafficking without discrimination. And the Home Secretary appears to misunderstand the very nature of modern slavery and human trafficking, as honourable members opposite have outlined also. Perhaps this could be accounted for by the lack of an independent anti-slavery commissioner, the post now standing vacant for a year. And the previous holder of this post, Professor Dame Sarah Thornton, gave evidence to the Home Affairs Select Committee last week on how the national referendum mechanism actually works. And I would suggest that the Immigration Minister goes and reads that evidence before coming to this House with such proposals as he has today. New Clause 26 replaces the placeholder Clause 51 and gives the Government the power to ignore interim measures from the European Court of Human Rights and remove people who would otherwise not have been removed. This clause hands powers to government ministers to unilaterally decide whether the UK should uphold its international obligations. Liberty have described this as a concerning shift of power away from Parliament and towards the executive. Yet again, we are seeing the stripping away of crucial checks and balances, another Westminster power grab, which has become the hallmark of this government. What this is really about, Mr Deputy Speaker, is about setting up a fight with the European Court of Human Rights, about setting out to breach international law. It's about sleight of hand and deflection from the Conservatives' failure to get a grip on the immigration backlog they created, thinking that if the public are somehow distracted by judges and their jammies, they'll forget about the incompetence of the ministers sitting opposite. I give my constituents and people up and down these islands more credit than that. Their heads don't button up the back. Mr Deputy Speaker, one of the most egregious aspects of the illegal migration bill is the impact on children. And the Children's Commissioners are crystal clear on the harm that this bill will cause, and the Immigration Minister should heed their calls. I'm happy on these benches that we will support amendments, New Clause 2, New Clause 3 and pregnancy, given the impact on both the mother and the child in these circumstances. Amendment 2 and 3 in New Clause 14 on safe and legal routes, family reunion for children, Amendment 5 on unaccompanied children, and New Clause 4 on an independent child trafficking guardian. And I would like to commend to the House the work of the Scottish Guardianship Service run by Our Lower and the Scottish Refugee Council, who do a diligent job in advocating for the young people in their care. And it is beneath contempt that the UK Government would seek to overrule the obligations which the Scottish Parliament has to children and young people and effectively prevent that system from carrying out its work, rebuilding the lives of unaccompanied asylum-seeking children. Our Amendment 54 would prevent the UK Government extending their harmful proposals on unaccompanied children to the devolved nations without their consent. We want to do better by our bairns, and it is despicable that the UK Tory government would block our democratically elected government from doing so. The government's new clauses 24 and 25 on age assessments are utterly ridiculous. These seek to automatically treat people as adults if they refuse to consent to an age assessment method, going against the Home Office's own advice from last year. The government calls these scientific, but the reality is that these are highly contentious. The British Dental Association have previously challenged the pseudoscience of such methods, saying that dental checks fail basic tests on accuracy and ethics. The Royal College of Paediatricians and Child Health have said the scientific evidence shows that pubertal assessment and bone age assessment are unreliable indicators of age and therefore cannot be used. And Gemma Jones, the chair of Unison's Science, Therapy and Technical Occupational Group, says that the plans break the code of conduct of radiography staff and their legal duties for radiation protection by instructing them to expose vulnerable individuals to ionising radiation without consent and without any medical need for a procedure that is not reliable to determine age. And this is important because this determines whether children get thrown in with adults, a clear safeguarding risk. And the appeals process is practically impossible and the consequences could be catastrophic. And I quote from an example given by the Scottish Guardianship Service of Shireen. Shireen was 13 when he fled Afghanistan in 2008. He arrived in the UK 2 years later, and the Home Office treated this 15-year-old as an adult and refused his case. He says, at that time was very difficult for me. I didn't know where I could go or what I could do. I had nothing and nobody believed my case. Now, the Guardianship Service was able to support Shireen and help him rebuild his life. And under this bill, that would not be possible. I acknowledge... I will.
That actually this works both ways. I have a constituent who offered her home to a 17-year-old asylum-seeking young man, and then he had all of the benefits of being under 19, but then actually revealed that the next birthday he was going to be 24. That safeguarding issues around both our own children and other children who come from other countries is something that we need to actually talk about openly and fairly.
I think she makes an interesting point, but the facts are that the medical professionals do not support the methods the government is suggesting to determine that. They just do not support that. If he's going to disagree with the British Dental Association, I'll take him to his point.
It's really great for the honourable lady giving way, and she'll know that I moved an amendment at committee, which the government have now refashioned and are moving now, precisely because there is a pedigree for this kind of testing across the European countries. Many of the European countries routinely use this sort of testing to establish whether children are actually children and avoid the eventualities that my honourable friend just mentioned.
The British Dental Association, the Royal College of Paediatrics and Child Health and Unison's experts disagree with him. These are professionals. Oh, I'm sorry, the Minister is laughing in the front bench and denigrating a trade union. Given the government's current position with industrial disputes, I don't think that's particularly wise of him, and he might want to think about that. Mr Deputy Speaker, I acknowledge the government's new clauses 134 and 136, but I am afraid I simply have real problems in trusting the government because detaining children is wrong, and that is the fundamental point here. The government proposed to make regulations in the circumstances of detaining unaccompanied children and further regulations on time limits. They do not have the courage to put this in the face of the bill, and they know that we can't amend statutory instruments should they deign to bring them in at some point in the future. We do not trust them to do the right thing here because children are children and it will be extremely harmful for them to be detained. Mr Deputy Speaker, we bring forward Amendment 47 to try and humanise this bill because there's a lot said about hordes of people coming here trying to claim asylum, but what this is about people. Fundamentally, this is about individual people, many fleeing circumstances that members in the benches opposite cannot even imagine. So we would seek to disapply this from a range of people. For example, people who were under the age of 18 when they arrived in the UK, like Shireen, who I mentioned earlier, and many others like him. People from Afghanistan, for example, where there's a real risk of persecution or serious harm if returned to that country. And you could call, when I did the previous stage of this bill, I tried to personalise them and put a name to each of these amendments. And I could call this Sabir's Amendment, after Sabir Zazai of the Scottish Refugee Council, the Chief Executive of the Scottish Refugee Council, who came here as a child in the back of a lorry. He would be prevented from so doing and criminalised and removed to Rwanda if the government had his way. And he makes an outstanding contribution to Scotland. He has 2 letters which he was going to put on the wall of his house. One said, it was a letter from the Home Office saying you're a person liable to be detained and removed. The second letter was one received from the royal family when he was awarded his OBE. C, a person who is a refugee under the Refugee Convention or in need of humanitarian protection, and that would cover many people who are fleeing from Sudan just now. Now, the Minister earlier failed to identify a proper, safe and legal route that somebody... No, he did not. He says he did. What he has done has pushed this on to UNHCR, who say that this is not their job. They have also said that the tiny minority, the 1% who managed to get onto a relocation scheme that they operate, are not suitable. There's not enough in that scheme to replace a functioning asylum system. It doesn't replace it, and that is what they have been very clear in saying. They have been very clear that that very small scheme, which very few people get access to, does not replace a functioning asylum system. So if my constituent, Ilyas, a British citizen whose wife and son are trapped in Sudan, they're not able to get their documents because the British Embassy staff are out of the country. Will they be able to come in some other way to the UK safely, even though they do have now the right to travel? Do those that happen to be in Sudan on a refugee travel document, perhaps with family visiting in Sudan, would they be able to get out and be evacuated by UK forces? It remains unclear. Moving to D, it would be a person where there's a real risk of persecution or serious harm on the grounds of sexual orientation if they were to be removed in accordance with this section. And I had a call, Mr Deputy Speaker, with LGBT rights activists in Uganda, where they are bringing in absolutely brutal laws to persecute LGBT people up to the point of the death penalty. People are terrified over there. They're talking about mob justice. They're talking about family being at risk for even knowing that their loved ones are LGBT. Now, if they were able to escape Uganda and get to here, there is no means under this bill by which the government would not protect them and send them back. So we seek to put that protection into this bill. E, a person whom there are reasonable grounds to suspect is a victim of torture. And I spoke at the previous stage of the bill of Kolbasia, who founded Survivors Speak Out. And I speak to people in my constituency at my surgeries who have been victims of torture. They deserve protection. They do not deserve this bill. F, I put a Ukrainian citizen, but there is no Ivan or Oksana that needs to come here in a boat, because there is a safe and legal route. They can come here perfectly legally. They can come here without having to resort to that. And we should be making that available to more people, and I'll take your intervention.
I'm listening very closely to what you said. When I was Children's Minister, every single local authority in Scotland, bar one, was refusing to take any unaccompanied asylum-seeking children. Why?
The lady may not be quite as well informed as she hopes she is. Every single local authority in Scotland took people under the Syria scheme, and they were proud to do so, and we took a greater proportion than the rest of the UK. We would be willing to take more people if the Home Office would only honour their side of the bargain. And the Minister's looking at me askance here. Now, because the Home Office is choosing where people go. The Home Office is booking hotels. The Home Office is not working with local government in Scotland to do this properly. And I can tell him that he's not working properly with local elected members, because I am aware of plans to put an asylum hotel in my constituency. I'm not. He asked me if I'm opposing it. I wouldn't know, because he hasn't given me the details of it. I've known about this since January, and he hasn't bothered to get in touch with me as a local elected member to even discuss it. It's absolutely ridiculous. Mr Deputy Speaker, Moving on to a person to whom there are reasonable grounds to suspect is a victim of trafficking or modern slavery. And I mentioned at the previous stage that this could be Eva's amendment, a survivor who was helped, supported by Tara and my constituency, who had come here and ended up trapped in sex work. And those people deserve particular help and support, which will be denied to them under this bill. And services such as Tara will find it very difficult to operate once this bill passes. H could be a person who has family in the United Kingdom who should be exempted, and you could call this Ibrahim's amendment. Ibrahim being a constituent of mine who had family stuck in Iran and has found it very, very difficult for them to get there. People shouldn't have to wait in situations of danger for the Home Office to get around eventually to processing their applications, because for many people that is a situation of life and death. They can't wait for the Iranian authorities to come and find them. They can't wait for the Taliban to come and find them. They can't wait to be persecuted or tortured or killed. People are fleeing for their lives, and the Home Office's very slow decision-making puts people at risk. And I could be a person who meets the definition of an adult at risk in paragraph 7 of the Home Office Guidance on Adults at Risk in Immigration Detention 2016, including particularly people who are suffering from a condition or have experienced a traumatic event such as trafficking, torture or sexual violence that would be likely to render them particularly vulnerable to harm. And I talked previously about Priya, a trafficking survivor detained in Yarlswood when she was pregnant and unable to access the services that would have kept her safe. And there are many people like that, and we will see under this legislation, Mr Deputy Speaker, more women, more pregnant women, locked up in immigration detention.
Shameful. Yeah.
Moving to Government Amendment 95, saying that it's not necessary for a person to be present in the UK to give evidence regarding trafficking. Now, Professor Dame Sarah Thornton, who I mentioned earlier, the former Independent Anti-Slavery Commissioner, gave evidence to the Home Affairs Select Committee last week on this. And she said asking for people to give evidence after they've been removed to the UK would be astonishingly difficult operationally. Complex and complicated, very, very challenging indeed. And I would question really the very efficacy of this process because there is no recognition of the difficulties that this will cause. Cooperation with people once they've moved away will be practically very difficult. Dealing with police forces in other parts of the world will be practically very difficult. And it's unclear the level of cooperation that will be required to get some kind of exemption to this removal and then give evidence after. What will those compelling circumstances be? And there is also within this no recognition of the trauma that this will cause to people. And Dr. Katarina Schwartz of the Rights Lab presented evidence this morning about the impact that this could have on prosecutions to the Home Affairs Select Committee. She said, if a survivor is heavily traumatised and being questioned by the police, they will not be able to give good testimony. She also said, the impact of decreasing support for survivors on both their own experiences in recovery and integration and on their ability to testify is enormous. She spoke of the benefit of doing it right to the person, to the prosecutions, and economically to the UK for having people come through a process and do well from it. Mr Deputy Speaker, this is a dangerous, atrocious bill. It rips up rights, it undermines our international obligations, it rides roughshod over devolution, it puts children at risk, it places those trafficked more firmly than ever back into the hands of those exploiters who will be more easily able to avoid prosecution due to the measures in this tawdry bill. It will not work. We will amend, but we know amendments are not enough to fix this unfixable bill. We know in Scotland that better things are possible, and we reject wholeheartedly this bill. And we are appalled at its imposition against the will of the Scottish Parliament and the Scottish Government. We on these benches, we say it loud, we say it clear. Refugees are welcome here. We reject this fascist, dystopian assault on human rights.
Theresa May.
Thank you, Mr Deputy Speaker. I wish to concentrate my remarks on Amendment 4, standing in the name of my right honourable friend, the member for Chingford and Woodford Green, which I have also signed, and Government Amendment 95. Before I do so, I just want to say one word about evidence, because the Minister again today indicated that in his view there is evidence that the Modern Slavery Act is being abused. He might, I apologise for sort of doing this to him again, but he might wish to have a look at the evidence that I believe was given to the Home Affairs Select Committee this morning by a representative of the Organisation for Security and Cooperation in Europe, who basically said there is no evidence to support the claim that the NRM is being abused. In fact, on the contrary, the evidence is that there is a low level of abuse, and went on to say that the biggest problem with the NRM was not abuse, but the big delay in providing an answer to victims, which of course is an issue which is within the government's control, because it's about the length of time the government own officials are taking to consider those cases. Can I say to my right honourable friend that I was very grateful to him for meeting with me last week to discuss my concerns about this bill that I'd raised at committee stage of the bill. I welcomed the apparent attempt by the government to improve the bill by making it better for victims of modern slavery, willingness to look at that. And then I saw Amendment 95, which, far from making the bill provisions better for the victims of modern slavery, makes it worse. And I believe that my right honourable friend was talking to me in good faith, but I have to say it's hard to see this amendment, Government Amendment 95, as an example of good faith. I would say rather it's a slap in the face of those of us who actually care about the victims of modern slavery and human trafficking. Of equal concern is the fact that it suggests that those dealing with this bill simply do not understand the nature of these crimes or the position of victims. The Minister wants to see an end to human trafficking, wants to stop the business model of the traffickers. I want to do that as well. Many of us do across this House. But the best way to do that is by identifying, catching and prosecuting the traffickers and the slave drivers. Government Amendment 95, by making it an assumption that victims do not need to be present in the UK to assist an investigation, makes it much harder to investigate and prosecute the traffickers and slave drivers. It's been shown time and time again that the ability of victims to give evidence is affected by the support they receive. They need to feel safe, they need to have confidence in the authorities. As Detective Constable Colin Ward of Greater Manchester Police has said, if we get the victim side right first, the prosecutions will eventually, naturally follow, alongside us doing the evidence-based collection of that crime. So support for the victim matters in catching the slave drivers. Sending victims back to their own country or to a third country like Rwanda will simply at best make them feel less secure and therefore less able or willing to give the evidence needed, and at worst will drive them back into the arms of the traffickers and slave drivers. And again, the representative of the Office for Security and Cooperation in Europe at the Home Affairs Select Committee today made the point that the UK has been leading the world in identifying victims that have been exploited in criminal activity. That tells us these people are vulnerable because they've been compelled by traffickers to engage in criminal activity. Disqualifying them from our ability to rescue them will put the UK in the position of no longer being able to identify them and will leave them to the mercy of the traffickers. So far from helping, Government Amendment 95 actually flies in the face of what the Minister and the government say they want to do in terms of dealing with the traffickers and slave drivers and breaking their business model. Now, the clause that it represents, which was, I think it was subsection 5 of clause 21, has been used by the government previously as a means to tell us that the government was providing more support for victims of slavery. But it's reversed that. It's making it even harder for victims to get the support they need. And as I say, I think that will be a setback for the fight against the slave drivers and traffickers. Now, I will now turn to Amendment 4. The purpose of this...
Just to make the point with her, because of course she's making a very good speech, the reality is that this poses the threat. So straight away, the assumption of 95 is you go. Not the assumption is you have to prove anything. You go first, and then somebody has to prove you have to be here. So what are they going to do when they look at that? They're going to say, we're off. So why do we give evidence?
Yeah, well, my right honourable friend makes a very important point. And this is why I think it's, I hope it's an unintended consequence of the government's amendment. But I fear, given the government's brought the amendment forward, that they knew all too well what they were doing with this amendment, because they just want people to leave the UK. But this, making people, assuming, as my right honourable friend says, that if somebody is identified, they are going to have to leave the United Kingdom, means they are less likely to give evidence. We will not catch so many and prosecute so many traffickers and slave drivers, and sadly, all too often, those individuals will return to a country where they will be straight into the arms of the traffickers and slave drivers again. Now, on Amendment 4, the purpose is very simple, which is to ensure that those victims who are in exploitation, in slavery here in the UK, are able to continue to access the support they need, which will enable them to find a new life here, or indeed in their home country, because not everybody who's been trafficked here for slavery wants to stay in the UK. Many of them want to return home, but be given the support that enables that to be possible. But Amendment 4, if that was accepted, would actually ensure that it would be more likely that the criminals were caught. What this bill says, if you're a victim of modern slavery who came here illegally, we will detain and deport you because your slavery is secondary to your immigration status. Now, it's always been important to separate modern slavery from immigration status. Modern slavery is not a migration issue, not least because more than half of those are referred to the NRM here in the UK as for modern slavery are actually UK citizens here in the United Kingdom. Modern slavery is the greatest human rights issue of our time. The approach in this bill, I believe, will have several ramifications. I believe it will consign victims to remain in slavery. The government will be ensuring that more people will stay enslaved and in exploitation as a result of this bill, because it will give the slave drivers, it will give the traffickers another weapon to hold people in that slavery and exploitation, because it will be very easy to say to them, don't even think about trying to escape from the misery of your life, from the suffering we are subjecting you to, because all the UK government will do is send you away and probably send you to Rwanda. The Modern Slavery Act gave hope to victims. This bill removes that hope. I genuinely believe that if enacted, as it is currently proposed, this bill will leave more people, more men, women and children in slavery in the UK. Another impact, as I've said, will be fewer prosecutions and fewer criminals being caught and put behind bars. I apologise to the Secretary of State for sort of bouncing him with the Greater Manchester Police evidence that I gave earlier, but I think it is very relevant and he needs to look at that. The Nationality and Borders Act is already meaning that people are not, people who, from the figures of those who get a decision from the positive decision from the NRM, are in slavery, are not coming forward because of the evidence requirement now under the Nationality and Borders Act. And so that is having a real impact, and that means fewer prosecutions of the criminals. I just want to mention the impact on children, and I would urge the Minister to listen carefully to the concerns of the Children's Commissioners. There are other members in this House, including my honourable friend the member for East Worthing and Shoreham, who have long championed through the process of this bill the issue of children. My concern is particularly on those children who are in slavery here, who are being cruelly exploited. Victims need support. The Children's Commissioner has cited the example of Albin, a 16-year-old Albanian national, came to the UK in September, yes, via a boat, trafficked for gang and drug exploitation. It was clear to Border Force that he was young, malnourished and had significant learning difficulties. Now, he was provided support, including from the Children's Commissioner's Help at Hand team. But the point that they make is, without the NRM decision, he would have not been processed through the immigration and asylum route as quickly, and he would not have received the adequate support to meet his needs. Upon receiving the positive decision from the NRM, the social care team were able to transfer him to a suitable placement. But that individual, that 16-year-old, would otherwise have found themselves being detained, potentially detained and deported by the government. So it is important that we consider the impact on children who are victims of slavery. I put the arguments earlier about making it harder to prosecute the slave drivers, and that covers child victims as well. But there may well be an added element for the traffickers to use to keep children enslaved. And by this I mean the situation in Rwanda. According to UNICEF, in Rwanda, over half of all girls and 6 out of 10 boys experience some form of violence during childhood. Children are usually abused by people they know, parents, neighbours, teachers, romantic partners or friends. Only around 60% of girls in Rwanda who are victims of violence tell someone about it, and the rate is even lower for boys. Now, I recognise that quote from UNICEF relates to people, children within an environment, in a community, being abused by people they know, but it is hardly conducive to an environment of the good care of children. Amendment 4 removes the problem by ensuring that those identified as being exploited into slavery here in the UK would still be able to have access to support provided under the Modern Slavery Act. We've led the world in providing support for those in slavery by what we've done here in the United Kingdom. This bill significantly damages the operation of that act. It's bad for victims, it's bad for the prosecution of slave drivers, and it's bad for the reputation of the United Kingdom. Now, I was grateful that the Secretary of State, my right honourable friend, said from the dispatch box that he was willing to talk and listen to us and see if we can find a way through this. I say to him quite simply that the best way through this is Amendment 4. That is what removes the problem in relation to the victims of modern slavery. So I hope the government is going to be willing to look very carefully at that amendment, to listen to what we have said. What we're talking about is not just what we say, but actually what those who are identifying and dealing with the victims of modern slavery are experiencing day in and day out. They worry that more people will be in slavery as a result of this bill.
Order, order. I will now announce the result of the ballot held today for the election of the chair of the new Energy, Security and Net Zero Committee. 384 votes were cast, none of which was invalid. There were 2 rounds of counting. There were 362 active votes in the final round, excluding those ballot papers whose preferences had been exhausted. The quota to be reached was therefore 182 votes. Angus Brendan McNeill was elected chair with 188 votes. He will take up his post immediately, and I congratulate him on his election. The results of the count under the alternative vote system will be made available as soon as possible in the vote office and published on the internet. I'm now going to call Dame Diana Johnson, after which I shall have to impose a 5-minute limit on speeches. Dame Diana Johnson.
Thank you, Mr Deputy Speaker. And it is a great pleasure to follow the Right Honourable Lady for Maidenhead. And can I thank her for highlighting the evidence that we heard this morning at the Home Affairs Select Committee on the issue of trafficking and modern slavery, and just again pay tribute to the work that she did around that pioneering piece of legislation in 2015. I think she's actually right that the government don't fully understand the law in this area of modern slavery and trafficking. And I want to support what she said about Amendment 95 and Amendment 4. I noted that the Minister, when he started, said that it is important that we get this bill right. And it is absolutely important that we get this bill right. And I want to again express my concerns about the lack of an impact assessment on this bill as we enter this final stretch for this House to have the opportunity to debate and amend this bill. The bill's impact assessment is now 7 weeks late, and it is wholly unacceptable that the House is being forced to pass this very significant legislation with no firm analysis on whether this will actually work and what the cost will be. According to the Refugee Council, the bill could be as much as £9 billion over the next 3 years. And I just want again to refer to the Home Affairs Select Committee report on small boat crossings, where we were very clear about the need for evidence-based policy making. And it is very regrettable that we have this bill which is being forced through really at breakneck speed with no time for pre-legislative scrutiny. And I know the Minister is now having to bring lots of amendments forward, government amendments, to deal with issues that perhaps should have been thought through before. And of course we've heard that he's going to reconsider the issues around modern slavery and trafficking as well. I want to just move on to the amendments that I've tabled in my name, but I just want to raise 2 particular issues.
The Home Affairs Select Committee, in the report I just referred to, made it very clear that international cooperation, respect and trust were essential to building the joint framework with other countries to tackle the problem of irregular migration. So I am disturbed that the government is hardening their stance on the ECHR, and I strongly oppose their latest amendment on interim relief, which I believe will breach our international obligations. And of course, we've just had two very eminent lawyers in this chamber united really in what they think that this is doing. And the former Attorney General said that this was setting out in legislation to allow the deliberate disobeying of our obligations. Yes, I'm happy to.
Thank my right honourable friend for giving way and congratulate her on the amendments that she's put down and the work that she does for the Select Committee. Would she agree with my constituents who've written to me that precisely on the issue she's just talking about, this really risks our reputation internationally as providing safe haven for those who seek protection from persecution, and that really we need to do all we can to make sure that that reputation is maintained?
I absolutely agree with what my honourable friend has just said, and reputation is important in this area. And I think the approach that's going to be taken on this particular point will hurt our country more than it helps us. For example, it will not help us to get a returns agreement with EU countries, which I think we all agree is necessary if we are going to start to tackle irregular migration. Now, likewise, whilst welcoming the government introducing measures in this bill on provisions for legal aid, I think that is a positive step forward. I am concerned that they don't acknowledge that there are currently legal aid deserts across the country that leave genuine asylum seekers and refugees and victims of trafficking without resource to legal advice. The sector is actually on the point of collapse, and access to OISC regulated advice is really hard to come by for the many people who desperately need it. So I hope that the Minister may well be able to set out how people will be able to access that legal advice and assistance. Can I also just refer to New Clause 8 and Amendment 11 and welcome the government moving on the safe and legal routes. And that again is in line with recommendations that the Home Affairs Select Committee made in its report. Now, at committee stage, I raised several concerns with the Minister about the lack of consideration to vulnerable children within the bill. This bill creates broad powers to detain unaccompanied children, removing essential safeguards and time limits that had previously been enacted by this House. Now, I know the Minister said in his opening remarks that he was going to support the amendments tabled by the Honourable Member for East Worthing and Shoreham on the detention of unaccompanied children, and I'm very pleased to hear that. But unfortunately, the bill as drafted at the moment will still allow the unlimited detention of pregnant women, ending the 72-hour time limit currently in place, and that was put in place by the government in 2016. It also abolishes necessary safeguards for children who are accompanied, undoing the protection put in place by the government in 2014. Now, the Equality and Human Rights Commission, the Children's Commissioner and the Refugee Council have all raised serious concerns about these proposed changes. Now, I agree completely with the issues that they've all raised, and that's why I've tabled Amendments 2 and 3 to uphold the existing detention limits for children, families with children and pregnant women. They were introduced by this House for very good reason and should be upheld. Limits on detention deliver essential safeguards for the most vulnerable people who arrive on our shores to ensure that while we process their claims, we keep them safe, we treat them with care, and we do no further harm. The UK has been a stalwart of this decency, but these specific detention measures within this bill, I believe, are a major step backwards for families, for children, and for pregnant women. So, whilst I welcome the government's amendments 134 and 136 and the support for the amendment tabled by the Honourable Member for East Worthing and Shoreham,
But even with these changes, the bill does not extend the appropriate protection to children with families or pregnant women. My amendments have cross-party support from right across the House, including the Chair of the Joint Committee on Human Rights, the Honourable Member for Edinburgh South, and the Chair of the Women and Equalities Committee, the Right Honourable Member for Romsey and Southampton North. And I hope the Minister will, even at this late stage, consider again whether anything can be done with these amendments. Now, if he's not minded to do that, I will, if necessary, seek to test the opinion of the House on this important issue. Now, I also welcome the government's change of heart when it comes to the ban on future citizenship for children born in the UK to parents who meet the conditions in Clause 2. And that delivers on at least half of Amendment 8 tabled in my name. But I just wish to firmly push back to the Minister that it still cannot be right, for example, that an 8-year-old child brought here by their parents would be forever barred from citizenship when they're an adult. So I raised this point at committee stage, and it seems to me it's a completely illiberal position to punish a child for the actions of their parents or carers. So will the Minister just look at that amendment again as well? I've tabled several other practical amendments which all underline the protections and considerations for children which I believe need to be addressed. And all are supported by the Children's Commissioner, and some have foundations in the Home Affairs Select Committee report on Channel Crossings. So I hope the Minister will consider them in that vein. The government's approach to tackling migrants, I believe, in this bill remains problematic for children. There are several measures and amendments that have been brought to the House this afternoon that could be adopted, which will still allow the government to deliver on their stated aims, but arguably both more effectively and practically. There are less headline-catching ones, but they will also uphold the essential safeguard provisions that this House has put in place over the years to protect victims of trafficking and modern slavery, unaccompanied asylum-seeking children, asylum seekers and refugees. And finally, I do just want to go back to the issue around slavery and trafficking. The Home Affairs Select Committee has started an inquiry into this issue, and we've been very fortunate that we've had evidence from late Baroness Butler-Sloss last week and from the former Anti-Slavery Commissioner, Dame Sarah Thornton, both of whom took the view that this particular bill will not help victims of modern slavery and trafficking. It will do the exact opposite. And I would ask the Minister, again, to listen to the experts in this field. And it's very notable that the two right honourable members on his side have already spoken, I think have made a very compelling case for why the provisions in this bill around modern slavery and trafficking need to be looked at once again. It may be the other place will take further views about this, but seriously, is the Minister really wanting to make it harder for victims to come forward and to ensure, I think as Dame Sarah Thornton said, that if a woman who'd been trafficked into this country after March the 7th was taken to a brothel, was repeatedly raped, but then managed to escape and seek help, would be told that no, there was no assistance that could be given to her and she would be removed potentially to Rwanda. Is that really how we want to treat people like that?
Order. Order. Honourable members will have noticed that we are endeavouring to call those who have amendments tabled in their names first. After that, we shall seek to accommodate. I and my successor will accommodate as many members as is possible. Natalie Alford.
Thank you, Mr Deputy Speaker. I rise to speak to Amendment 184 in my name, supported by my Right Honourable friend, the member for South Holland and the Deepings, and many other Right Honourable and Honourable friends. The Stop the Boats Bill is important to my constituency of Dover and Deal because it specifically focuses on the problems of small boat arrivals. It does this by dramatically reducing the pull factors that draw people to the United Kingdom, namely that once people are here, it's very hard to remove them. This bill cuts through all that. Plainly and simply, it says that if you've arrived here illegally, you won't be allowed to stay. I've long said that the small boats crisis will only end when migrants and people smugglers alike know that they will not succeed. It's the right and compassionate thing to do to stop the boats. It will save lives being risked in the Channel. And the amendments today and the bill, particularly new Schedule 1 and other measures being taken, will send a clear, unmistakable message to would-be Channel migrants. If you are thinking of breaking into Britain in a small boat, don't bother. Save your cash and stay safe on land. So let me turn to the details of Amendment 184. Clause 4, to which Amendment 184 relates, sets out the circumstances when human rights and other protection cases can be excluded. Put simply, if a person arrives through the small boats route, they will not be allowed to try to stop their removal through endless legal appeals paid for by the British taxpayer. Amendment 184 specifically focuses on those who would put our public safety or national security at risk. This is in line with the UN Refugee Convention and the European Convention on Human Rights that has always allowed countries to protect themselves from those who would cause the most serious risk of harm to them and to their countrymen and women. So Amendment 184 would apply whether or not the country of origin can be identified. For example, if someone is undocumented, perhaps because they have eaten their identity papers or thrown their passport in the Channel, or as border officials tell me has shockingly been the case, has taken razor blades to their fingers to damage and destroy their own fingerprints to avoid identification. At the front line of my constituency in Dover and Deal, this is not a matter of open borders fervour or pro-migration ideological dogma, as some contributions today suggest. It is a matter which directly affects my constituency and our country's safety, security and peace of mind. A key reason why the Small Boats Bill and Amendment 184 matters is that when Dover and Deal residents raise matters of concern, the party opposite, the official opposition, doesn't back them and doesn't even believe them. When migrants ran amok and broke into a woman's house before being apprehended in a bedroom, the leader of the Labour group on Dover District Council went on TV to cast doubt on residents' accounts, dismissing them as misreportings. He said that we should be, and I quote, more generous to illegal Channel migrants. The reality is that Labour's amendment, New Clause 15, is a smokescreen for allowing more legal challenge and more taxpayer costs, more potential loopholes to allow those who would wish our country harm to stay here. Subsection 2 of Labour's New Clause 15 would require a Secretary of State to consider putting illegal migrants suspected of terrorism on the Terrorism Protection and Investigation Measures, the TPIMs, if they can't remove them. But as the Minister has already said, the government is doing this anyway, and it will always act to protect the national security of the country. If the benches opposite want to ensure our country's safety and security, they should back the government's Stop the Boats bill, and they should back swift removals. Because their amendment pretends to be tough, but in fact it would result in fast-track appeals. It would result in slower appeals than the fast-track process that the government has set out. In my constituency, we see Labour's true colours. It's an open borders, pro-immigration party. It doesn't want to stop the boats. Just like Brexit, so on small boats. Labour cannot be trusted, and it doesn't listen. I thank the Minister for engaging with us on Amendment 184. I have had the reassurance I've been seeking, and so have my honourable and right honourable members who have supported it. So we won't today be pressing for a vote, and I look forward to continue to engaging with him to stopping the boats.
Stella Creasy.
Thank you, Mr Deputy Speaker. Let's be very clear. Demonising refugees won't tackle the cost of living crisis in this country, but it might create some local election leaflets, just like this piece of legislation. We know this legislation will not survive the other place, thankfully. So the question for us today is, what are the messages we need to send to our colleagues in the other House as they scrutinise and hold to account this government, given this government has systematically failed to provide the time for the scrutiny in our place? First of all, we need to tell them this government has no idea how to solve the problem that we all want to fix, which is stopping the boats and stopping the traffickers. Nothing in this legislation targets the traffickers themselves. There's no increase in actual deterrence to them, no increase in sentencing, nothing about joint enterprise, for example, nothing about those people who are illegal overstayers here that could have been brought in to deter the traffickers. I agree with the member for Maidenhead when she said this will simply help those who engage in trafficking because it will allow them to threaten those people who might come forward. Secondly, this tells us this government doesn't respect the role of international rule of law or why it matters to have international cooperation if we actually want to address these concerns. Imagine if every country took the approach that the Minister did when he was trying to say that nobody should claim asylum in the UK. They should go and do it somewhere else. The whole system would collapse. It's by working with other countries, upholding the European Court of Rights and doing our bit that we will manage this issue better. Thirdly, it tells us the government has no idea what modern slavery is at all, but frankly, I'm not sure they really care, given the reaction of the government, who time and time again talk about evidence but produce none to back up their claims. Fourthly, it tells us they don't really care about the children who are already on our doorstep. I'm glad to see the member for East Worthing doing the work that he's done, but I have to tell him I am very sceptical that we will see meaningful change, whether for children who are accompanied or not, because every refugee child in this country is vulnerable. The children in the hotels in my constituency who were sexually assaulted were with relatives. Those children who've gone missing have family who are looking for them. The Children's Commissioner is terrified, and that's why I have tabled my amendment for Amendment Clause 2, remove children and pregnant women from Clause 2 of this bill, but I will support the amendments by my colleague from Hull as well. The age verification processes that sound like something out of a Margaret Atwood novel, yet somehow the government ministers want to support them. The removal of the Independent Family Review Panel. Finally, this government clearly doesn't understand that it's not a focus on travel we need, but the threat that people face if we really want to tackle it. That's why safe and legal routes matter. Because the minister can rumble on at the dispatch box, he can avoid questions, he can remove basic protections and decency standards so that we are waiting for refugees to live in maybe the Grenfell Tower without smoke alarms, without safety. Well, the minister's main vote, he hasn't explained why he's put forward that statutory instrument. People will still come because it is still better than the death that they face in the country that they are fleeing from. And we see that with the Sudanese. The minister said earlier that he would listen to the UNHCR when it came to taking Sudanese refugees. Well, then he needs to tell us how many he will take, because right now there are people facing that very same situation. There aren't any queues in a war zone. With the greatest respect, I've listened at length to the member from Stone and yet to find any common ground on these issues. And frankly, it's about time we stood up for the importance of international rule of law, and it's about time that we stood up for the importance of helping people when they are facing situations. There aren't queues, there aren't administration, there isn't bureaucracy in a war zone. There's fear, there's terror, there's persecution, and those people in Sudan now will be asking those questions. Now, the minister wants to answer that question and give them hope that actually if they make it to the border and they make it to one of those refugee camps and they find one of those UNHCR people who doesn't think that actually they have this relationship with the UK, but he's prepared to do that, and that we'll take a certain number of people, that might stop them fleeing. This legislation will not, and more people will keep coming, whether they come from Afghanistan, where the government has failed to bring in a safe and legal route, and where the government still fails to listen to those of us who have constituents who've been affected by that. They will come from Eritrea. They will come from the war zones, the persecution, the people whose religion means that they are at risk. They will come because they see what we did with the Ukrainians, they see this country, and they know that there is a better way of doing it. The Lords will take this legislation on. That's probably the point of it for the government. But let nobody be under any illusions. This is just about May the 4th. This is not actually about resolving this problem.
Tim Lawton.
Thank you, Mr. Deputy Speaker. It's difficult to know in 5 minutes how to address the 5 amendments which I have with my name at the top, including those two which have been leapfrogged by the Home Secretary, and particularly given the many hours I've been cosseted with the Immigration Minister and others to try and get some of the adjustments here. I'm grateful for the time that he's spent to try and get us to a better place. I certainly don't have time to respond to the very extensive assurances which he aimed to give me from the dispatch box earlier, but I support safe and legal routes. I'm glad we now have them on the face of the bill. We need a balance, because I support this bill. If we're to be tough on the abusers of our immigration system, we have to make sure that we are open and generous to genuine asylum seekers to whom we owe a duty of care. So the amendments on safe and legal routes are also very timely, because we needed to address the question which I posed to the Home Secretary some months ago about how the 16-year-old orphan from East Africa with relations in the UK made it to the UK. This week, that apocryphal scenario became a reality. So the measures which the Minister will be bringing forward need to address that question. He's going to consult with local authorities about capacity. That is essential. But he also needs to consult with refugee organisations and others about the type of the schemes that we're going to come forward with. How will they operate? Who will qualify for them? How will people access them? And let's make sure they're in place sooner rather than later in 2024, even though I'd like them to have been contemporaneous. Here we have a deal on safe and legal routes, but we need to see some real and workable details in the coming months and as the bill goes through the Lords. I have no time to talk about the Amendment 181 on return of children or 182 on best interest and welfare checks. My real concern has been on child detention, so I was grateful for the assurances that the Immigration Minister gave me, because as the measures stand, they do not differentiate between children and adults on detention terms. They ride roughshod through the 2014 immigration safeguards on child detention, which specifically under this government specified the 24-hour limit on the face of the bill, and they don't even offer to put the maximum detention times for children on the face of the bill. So that is a must when it comes to any amendments which the Minister is able to bring forward in the House of Lords on the face of the bill. I will, of course.
I'm very grateful to our honourable friend and very much agree with the points that he is making in support of children. Will he also agree that we need absolute clarity on the responsibilities under the Children Act 1989 in all circumstances when a child is on these shores, in particular when the Home Office have some responsibility themselves?
That is absolutely right, and it's notable there are 3 former children's ministers behind these measures we're trying to push today, because it's really essential that any child in this country, whether you are a refugee here temporarily or somebody who's been here for the long term, is covered by the Welfare Considerations for the Children Act. So I'm grateful again there was a reference to the Children's Act in what the Minister says earlier. Because again, as it stands, despite the measures that mean there will be a differentiation between children and adult detention, we don't know how many yet, it still means the 12-year-old child claiming asylum could be in a detention centre facility from the Home Office for 27 days. That is not a good look, and it must not happen. I'll give way.
Can I add my voice to the chorus of former Children's Minister on this issue? Does he agree with me that this period for which a child could be detained when they first arrive in order to find them suitable accommodation needs to be a matter of days, not a matter of weeks, and needs to be on the face of the bill?
I agree, and that's what we put on the face of the bill. The then Immigration Minister, now Transport Secretary, in 2014. So what has changed between 2014 and 2023 that apparently we have to treat children definitely? So we need timescales on the face of the bill, as we did in 2014. I appreciate there are problems, practical problems, about age verification for those who have a challenge. We may have to have a 2-tier system, but certainly those children who are recognised generally as children should not be locked up in detention centre, in Home Office facilities, and that has got to be made absolutely clear when this bill goes to the Lords. We also need to know how and where the government plan to accommodate those children once identified. The accommodation does not exist at the moment, and they've only a few months to magic it up if we want to get this legislation through in a matter of the months. So I share the Children's Commissioner's concerns. She says the bill is unclear on what the state of the accommodation will be for children whilst awaiting transfer to local authority care or removal from the country, what regulations will be in place for Home Office provided accommodation if the accommodation is regulated, which body will inspect them. There are a lot of questions to be asked. We are taking the assurances from the Minister on trust. We will not continue without a lack of detail when this bill gets to the Lords. But for the moment, we're not going to force it to a bill because I trust the Migration Minister to do the right thing before this bill finalises its stages.
Absana Begum.
Thank you, Mr Deputy Speaker. I rise to speak to a range of amendments and new clauses seeking to protect people from the attacks on basic human dignity that are before the House today. I am supporting clauses in the name of the Honourable Member for Streatham about the ongoing human rights breaches that migrants endure, which have been happening for some time. But today I am focusing on how the legislation treats those who are pregnant, because not only will the illegal migration bill persecute and imprison people fleeing torture, war and oppression, it will take some of the most vulnerable of these, pregnant women, and put their health and the life of their unborn children at risk. That's why I've tabled new clause 2, which seeks to exempt pregnant women and girls from provisions about removals. My new clause 3 seeks to require an independent review of the effect of the provision on pregnant migrants, and my new clause 7 is about a review on the effect of the measures on the health of migrants. I'm also supporting related amendments to prevent an immigration officer's detention powers from being used to detain unaccompanied children, families with dependent children or pregnant women, and to prevent the Secretary of State's detention powers from being used to detain unaccompanied children, families with dependent children or pregnant women, as tabled by my honourable friend, the member for Kingston upon Hull North. In order to cut through the dehumanising othering that too often plagues debates around migration, and I note those comments made earlier today, the awful nature of the comments made earlier today in response to the Honourable Member for Glasgow Central about the dental testing of young migrants, which I find dehumanising and othering of different communities. I would actually like to draw attention to the House of a real-life example to illustrate the human reality of what is being debated today. Najma Ahmadi and her family fled from the Taliban and made 20 attempts to cross into Greece from Turkey. 20 attempts. On 2 occasions, Najma nearly drowned, once while pregnant with her baby daughter. She did finally arrive in the UK last July on a boat, her terrified 1-year-old baby girl clutched against her. Najma and her family were entitled to asylum, which was granted last December. But we must not forget that there are also those pregnant women escaping persecution who have died seeking refuge. For example, Johanna, an Eritrean woman thought to be about 20 years old, who gave birth as she drowned alongside many others when the boat she was travelling on, trying to get to safety, capsized. And there are many other women who remain unnamed. These women are not criminals, Mr Deputy Speaker, but this government is proposing today to treat them worse than criminals. And this is despite knowing that such women are in fact victims of foreign policy failures and the simple, indisputable fact that there were no safe routes for them. They're fleeing countries such as Afghanistan, and Afghanistan's barely had a mention today. And I mention Afghanistan because as of last month, there were, and I raised this at the previous stage of the bill, there were 22 people that were granted asylum through the Afghan resettlement scheme. If that figure has changed, I'm more than happy for the Minister to address it in his closing remarks. But that's such a small number, unless, of course, the government have changed tact and don't think that there are women trying to escape the Taliban in Afghanistan and that they don't deserve safe routes for them to escape. Not only will the government refuse sanctuary to those that survive these horrors, but Clause 11 will enable the Home Secretary to condemn them to indefinite detention. This bill will therefore see migrant women who should have finally escaped persecution facing pregnancy and birth alone, without adequate medical support and with the fear of potential separation from their baby. Now, there is a wealth of information and evidence that the imprisonment of any pregnant woman is wrong. We know that pregnant women in prison are almost twice as likely to give birth prematurely, and that pregnant women in prison are five times more likely to experience a stillbirth. Yet pregnant refugees are to be placed in circumstances worse than the already inhumane situation of pregnant women in UK prisons. In places like Manston, where there are outbreaks of illness and disease, reports of assault and drug use by guards, which last year was estimated to be detaining thousands of people arriving in Britain via small boats, some for as long as 40 days or more. No one should be detained in such places, never mind those who are pregnant. And the BMA, the Royal College of Midwives, and Maternity Action have all raised that healthcare in immigration detention is often very poor. In 2014, 99 women were locked up in Circle Run Yarlswood Detention Centre while pregnant, and research by Medical Justice found that they often missed antenatal appointments.
The honourable lady is out of time. David Simmons.
Thank you, Sir Roger, Mr Deputy Speaker. There are many things one could say about this bill, and certainly my extensive backstory really in dealing with issues of asylum and migration means that there are many elements that I think it's appropriate to draw the House's attention to. But it's important to start by saying, as many colleagues have said, that we all share the aims that this bill sets out to achieve. We cannot allow a situation to continue where significant numbers of people are putting their lives at risk, and in some cases, tragically losing their lives in the English Channel. We need to find a better, more robust and effective way of managing our migration process. I'd like to focus my attention in the short time available on a couple of issues of principle and a couple of practical issues which I hope ministers will give attention to, which I'm sure will be the focus of debate in the other place. I certainly commend the work that's been done for the member for East Worthing and Shoreham and the Right Honourable Member for Maidenhead, and very much welcome the assurances that have been received in response to the work that they have done. But I'd like to start perhaps by touching on the aspect around age assessment and the impact of Local Authority Children Act duties, and the need to ensure that by the time this bill completes its passage and gains royal assent, that we have absolute clarity of what we expect of our local authorities and of how that process will interact with both this legislation and other legislation such as the Leaving Care Act, which imposes specific responsibilities on local authorities in respect of all young people, regardless of their immigration status. Now, it's very clear that in the debate about scientific methods, and those who've read what the Interim Age Assessment Advisory Committee have said, a report that's been published by the Home Office on its website, will be clear that scientific methods, as proposed, envisage at best a minimum age range that could be assigned to an individual. It envisages that the Merton-compliant local authority age assessment process will continue as being necessary and required. And what we need to ensure is that we do not end up in a situation where a local authority or other public bodies being judicially reviewed for failing to carry out its duties under, for example, the Children Act or the Leaving Care Act, whilst seeking to be in compliance with its duties in respect of immigration under the Illegal Immigration Act. And I'm pleased that, having met with the Minister on this issue, he's indicated that he will return to me on a number of those points. But it is important, if we are not to undermine public confidence in the effectiveness of this legislation, that we address that issue expeditiously. The second issue of principle, which I would like to draw the House's attention to, is the impact of the so-called Rule 39 point, the issue about interim reliefs being provided by the European Court of Human Rights in Strasbourg. Now, the Brighton Declaration was a recognition some years ago by the European Court of Human Rights that there was a need to recognise the concern of a number of the member states about those areas where the actions of the court had departed from some of the things that were perhaps originally envisaged in the treaty or that are specifically enshrined in law. So there is clarity that the Strasbourg Court and its judges recognise that there is concern about the operation of some of these matters. It does, however, seem to me concerning that what is envisaged in here is that the only circumstances in which such an interim measure would be relevant is where the Home Secretary considers it to be so. So the default position is that we will always ignore our international law commitments unless we choose to follow them. And that is something which, as a party that seeks to uphold in all cases and all circumstances the rule of law, we should be concerned about. I draw the House's attention to my register of interest in the respect that the next point on our links with other countries, and in particular returns agreements, I've had the benefit of a lot of research support looking at the relationships which the United Kingdom has with other countries. And clearly, if we're not to create a situation where significant numbers of people find themselves at very significant taxpayer cost in detention in the UK for long periods of time, we need to go immensely beyond what is envisaged in the Rwanda Agreement and established returns agreements in particular with EU neighbours and other countries as well. But all of those points, it is my understanding from the assurances that I've received from ministers and the government, will be addressed over the process of the passage of this legislation. And in order to achieve that point, which we all share, I therefore will be supporting it tonight.
Sir Chris Bryant.
Thank you, Sir Roger. I hate the crossings. I hate every single aspect of the crossings. It's a traffic for a start. It turns people into a commodity, in particular extremely vulnerable people. I've heard stories that often the traffickers deliberately buy dinghies that are more dangerous because they are hopeful then that they will be picked up by other people. That is despicable. They are deliberately putting other people at risk. It's also a sign of international failure of diplomacy in other parts of the world. In Afghanistan, most notably, Iran, Syria, no doubt we'll have people from Sudan in the not too distant future as well. It's chaotic, it's unregulated, there's no opportunity of justice or proper priority for those who are most in need. So I absolutely hate it. And of course I know that emotions run extremely high. Emotions on behalf of those who are being trafficked themselves. Most notably, they're in fear for their lives. They're terrified of being spat at, of being hated, of being in an environment which they don't know, where they don't speak the language properly, and all the rest of it. But also, of course, for many people in this country who watch it, they have compassion mixed with anxiety, mixed with fear, all of that, which is why I just say that I think that language that we use about this is so, so important. And I say very gently to the Minister, I really didn't like when he started using the language about breaking into this country in a previous debate, and using the word cannibalise, I think, in relation to this today is very, very unfortunate. I just urge him to think, I know he's a decent man, I just urge him to think about that language. I don't incidentally buy the fundamental premise of the bill either. If it really were trying to prevent some kind of deterrent, then I think this would have been thought through much more carefully. I don't believe deterrent is really the matter of it. The push factors are far more significant in determining who ends up on a boat than the pull factors in the UK. And insofar as there is any evidence as to what the pull factors are, they are that we speak English in the UK, and lots of people who are more likely to speak English than French or German or Italian or Spanish. Secondly, that they already have other family connections in the UK, so they think they might be able to base themselves here more easily. And thirdly, we have the rule of law. And all of those things are not going to change. I passionately dislike the interaction with the modern slavery legislation in the UK. The Right Honourable Member for Maidenhead has said it far more effectively than I. But I just look at Amendment 95. This is the worst piece of gobbledygook I've ever seen introduced. The Secretary of State must assume for the purposes that it is not necessary for the person to be present in the UK unless she considers that there are compelling circumstances. And in determining whether there are compelling circumstances, she must have regard to guidance issued by herself. I mean, she's going to be in an endless discussion with herself. It's just preposterous, and I think it completely undermines the good efforts that have been made over many years to try and make sure that we really can crack down on the traffickers, because the best person to be able to reveal a trafficking ring is a victim of that trafficking ring. Without that willing cooperation from those people, we simply give more power to the traffickers. I also dislike the interaction with our international commitments. The former Attorney General, I think, made the point earlier that in essence this bill is asking us deliberately to say that a minister can breach our international commitments. I just say, as somebody who has probably been the longest standing critic of President Putin in this House, and has been saying this for a very, very long time, I do not want us to be in a very small group with Russia and Belarus as people who have left the European Court of Human Rights. That, in the end, would do a terrible disfavour to British prosperity in the world. Of course, I give way to the...
What the former Attorney General said, I thought an extraordinarily contradictory contribution to our affairs, was that these judgments were not compelling. We weren't compelled to abide by them, and indeed we didn't in respect of prisoner voting, and yet complained that because we're saying in law now that we're not compelled to follow them, there was something wrong with it. So either you believe that we are obliged to follow these judgments, or you don't. And we, in fact, the truth is, we shouldn't be following them.
Look, I think there are times when we want to disagree with a ruling of the court. We, as the Labour government, certainly did so over whether prisoners should have the right to vote, and we ended up with a lengthy process. I can't even remember where we ended up on that one. So I'm not opposed to having a disagreement with the court. That can sometimes happen. But I think that what the bill asks us to do is to say that the government, and especially with the amendments that have been tabled, I'm afraid, in his name and the name of others, is deliberately asking a government to front it up with the European Court and the European Convention on Human Rights. I think that in the end will do us long time harm. When we want to have a conversation with China about abiding by international rules-based order, I think it just makes it more difficult for us to do that when we are offending our own treaty obligations. It's a perfectly legitimate question that Labour MPs often get asked, well, what would you do? If you don't believe in this bill, what would you do? Well, for me, I think the first thing, I referred to it earlier, is I think I want a comprehensive a security treaty between the United Kingdom and the European Union. I think that was what we always wanted at the beginning of the of the Brexit process. The Right Honourable Lady was quite right to argue for it. I don't know why that isn't on the table again now. It would solve many of the problems that we're seeking to address here. Secondly, of course, we should make it easier to arrest the traffickers. We need to devote more time, energy, money and international cooperation to make that happen. And thirdly, we need to process the backlog faster, because the more people who are stuck in the backlog for months and months and months, the more the costs to the British people, the more there are hotels or whatever other arrangements that are made, and that is wrong. Finally, I honestly don't think that anybody will be proud of this legislation in 5 or 10 years' time or 20 years' time. I think it will all be undone, I hope, by a future government. But I don't even think that the Immigration Minister will be mentioning it in his memoirs.
Sir John Hayes.
I'm extremely grateful, Mr. Speaker. Edmund Burke said that justice itself is the greatest standing policy of civil society, and any eminent departure from it under any circumstances lies under the suspicion of being no policy at all. Mr. Speaker, defending our borders and our ability as a sovereign nation to remove people who have no legal right to be here is a matter of justice. Legally just and socially just. And so, by the way, is our right as a parliament and a government to say how many people should come here lawfully. And I just suggest gently to the Minister that he needs to look next at legal immigration and the record numbers of people who are coming here and the visa system which allows that. All of that matters to my constituents. I humbly propose that it matters to the constituents of members of this House from Ruislip to Rhondda, from Worthing to Walthamstow, just as much. Because every poll that's taken, every test of public opinion, says that the British people want to stop the boats crossing the Channel. Because, as the Honourable Member for Rhondda said, not only does it endanger the life of those people in the boats, it also offends the principle that I just set out, that a nation is no nation if it can't control its borders. Now, there are those on the opposition benches, despite the rhetoric we've heard, who really are paying lip service to immigration controls. I believe, and many of the people I represent believe, I would say the vast majority, there's been too much immigration into Britain for too long, and immigration is a salient for them in a way that it just isn't for many people opposite. And outside this place, the shrillest opponents of this legislation, the fiercest critics of the Home Secretary, include those who are deluded and those who are devious. Deluded in refusing to accept the reality that many of the people arriving on these boats are economic migrants. Gained by dodgy interest groups and devious lawyers to support spurious claims exploiting the capricious perversity of European judges who no one in my constituency chose and are not accountable to anyone in this chamber or indeed in this country. The trouble is, there are people who don't believe in the integrity of our borders because, in essence, they don't believe in the integrity of our nation. I would happily give way. to a lady who does believe in the integrity of our borders and our nation, I hope.
I do. I listened to what the Honourable Member was just saying about the problem of European judges. Can he refer to a case from the European Court of Human Rights where they've demonstrated a lack of respect for our immigration laws?
Well, I mean, I gave a case not on immigration, but on something which is as if I can put it that way, as vivid as the issue of immigration, on prisoner voting. And he will know that successive governments opposed prisoner voting, including Labour governments and Conservatives, and in the end the matter was dropped. So that's a very good example of where the European Court was dismissive of the traditions and character of how we do things here. Now, Mr. Speaker, I commend the Prime Minister and the Home Secretary for strengthening the bill further by a variety of means. That means we can ensure we deliver on our promise. New Clause 22, in the name of the Home Secretary, will restore the kind of common-sense justice the British people are crying out for. It will stop the courts granting interim remedies that delay removal of people who should not be here and who the public rightly expect the government to remove. New Clause 26 will ensure the Home Secretary has the power to remove people who have entered the country illegally and have no recourse to stay. When the British people see the human rights lawyers making a 4 a.m. dash to stop planes of people being deported, they know that our system is broken and they want it fixed. And they wonder why those with power seem powerless to challenge all that. And that exposes, indeed it epitomises, the gulf between the prejudices of the liberal establishment and the sentiments of the people whose power they affect. The British people elected us in this chamber to make laws to keep them safe. And New Clause 25 refers to essential age assessments, and that will help to keep us safe. What angers people is the unfairness where migrants claim to be younger than they are in order to game asylum rules. Just a week ago, the press reported the story of a legal immigrant who smuggled himself into Britain, claiming to be 17 years old. He was actually aged 42 and a former ISIS member. According to the story, he spent up to a week in a local authority residential facility with children under 18 before his lies were exposed. That does not keep people safe. In a scientific age, assessments can be carried out and are carried out in countries as varied as Finland and France, in Sweden and in other European places. They are well established and they work. I won't because time does not permit. Forgive me. The amendment that I moved in committee and has now been brought forward by the government will do just that, put in place those scientific tests to establish beyond doubt the age of claimants. We've seen almost 90,000 people come here in small boats in recent years. It costs £6 million a day to accommodate them in more than 300 hotels. In order to re-establish the faith of the British people, that the government and this House understands their concerns about all that. It's as simple as this. We must deliver this legislation because we must stop the vote.
Yeah.
Kim Leppard.
Thank you, Mr Deputy Speaker. I'm very interested now as whether I am part of the Liberal establishment.
Definitely.
I'm also,
Absolutely,
as a working-class girl from Yorkshire, I'm struggling with that concept a little bit. I wonder whether the Right Honourable Lady for the member for Maidenhead is part of the Liberal establishment, of which has been spoken.
Oh, yes.
Anyway, moving on. On this side of the House, we are very clear that the tide of illegal migration to this country must be stemmed. We're also very clear that the appalling rise in the numbers of people risking their lives in small boats to cross the Channel is a damning indictment on this government's failure to secure our borders, and that deflecting blame for their failure on each and every person who gets in a boat at great risk to themselves because they have no other option is shameful and wrong. I rise to support Amendments 2 and 3 in the name of the Chair of the Home Affairs Select Committee, and in the hope that ministers will recognise the inherent injustice in this blanket approach, and that they will reflect on the need to address the issue on the basis of what works and not on what they believe will reverse their poor poll ratings on immigration. The truth is, Mr Deputy Speaker, that people are sick and tired of hearing from successive Tory Prime Ministers and successive Tory Home Secretaries that they are finally going to get tough and sort out the mess they themselves have made of our immigration system. If we want to address the growing cynicism in the country about promises made from the dispatch box that turn out to be hollow, ministers have to give up their addiction to divisive and dangerous language and headlines and get serious about the issue of illegal migration.
Would the Honourable Lady give way on
I
that
will.
point? Was the Honourable Lady dismayed as I was by the comment of the Minister earlier today about cannibalism referring to refugees?
I thank my honourable friend for her intervention. I agree wholeheartedly. I worry on many levels sometimes about the language that is used in this place and the impact it has on the outside world, and I think that point has been made very well by my colleague, the member for Theronda. And we all need to think about the language that we use and the words that we say and the impact it can have on people outside this House. So what we need is a thorough, workable and deliverable plan, which is what we on this side of the House have put forward and which has been brilliantly articulated by the Shadow Immigration Minister this afternoon. And what distinguishes Labour's plan is not only that it is practical and tough on the real criminals, but also that it's rooted in justice and in fairness. I note that ministers have described this bill as the morally just thing to do. I beg to differ. There is absolutely nothing fair or just about detaining children, nor will it do anything to deter the criminal gangs. Equally, as we've heard, imprisoning pregnant women and those with dependent children undermines the moral basis of the policy without achieving any benefit. This would be true whether or not the government had a good record of protecting vulnerable people, either in detention or Home Office accommodation, which they clearly do not. Justice and fairness cannot be cast aside lightly. They are at the heart of what makes us all proud to be British. They underpin our values and should be the guiding principles behind everything we do in this House. And unless the system is both just and fair, it will fail, like every other so-called crackdown that has done nothing to stop the boats. It will not only fail to work, it will fail to convince the public that the government is serious about stemming the illegal flow of immigration. And therefore, I urge the House to support these amendments.
Vicky Ford.
Thank you, Mr Deputy Speaker. As I said in the previous debate, I support the premise of the bill. Too many people's lives are put at risk on small boats, and it is important to break the model of the people traffickers. And we're also spending millions, indeed billions of pounds of our aid money on hotel for some tens of thousands of people in the UK, but that money should be being spent on helping millions of people elsewhere, millions of people in countries like Sudan. I've just met Save the Children from South Sudan who are telling me already about their expectation of children coming across the border, children who need help, and where without help these countries will become even more unstable and more people will be forced to flee their homes and more people will try to get on those small boats. The small boat route is also extremely unfair. No country has an unlimited capacity to support asylum seekers, and those arriving by illegal routes reduce and limit our capacity to provide safe and legal routes which will help the most vulnerable. As I said in the previous debate, the introduction of the new safe and legal route does need to go hand in hand with closing down illegal routes. I'm very grateful to the government for listening to this and have co-signed new Clause 8. On the issue of how children should be treated, I'm extremely grateful to the Minister for meeting me and my honourable friend, the member for East Worthing and Shoreham, and listening to our concerns. I know that my right honourable friend, the Immigration Minister, takes the issue of the welfare and safeguarding of children very seriously. And I understand we must be careful not to create perverse incentives to people traffickers which would force them to target even more children and send them on small boat crossings. But the issue of depriving a child of their liberty is a very, very serious issue. And we have very strict rules in this country regarding the protection of children. I'm very proud of those rules, and many of them were introduced by this Conservative-led government. Depriving a child of their liberty can have a serious and long-lasting effect on their mental health, and therefore there do need to be very strict rules. This is why I signed Amendment 183, which makes it clear that a child's liberty can only be restricted for a very limited period of time. I am grateful to the Minister who's listened to the concerns of myself and other former children's ministers on this subject, and I listened closely to what he said at the dispatch box. I'd like to thank him for the assurance that he has given that he will work with my honourable friend to set out a new timescale on this deprivation of liberty issue. This needs to be very clear, it needs to be in the face of the bill, and it should be a handful of days, not a number of weeks. That is to make sure that children are prioritised, because children are often those most at risk. We do also need to be wary, and I agree, we need to be wary of the risk of creating an increased incentive for more adults to claim to be children. I recognise that some of those who claim to be seeking asylum are actually adults, but it's roughly 50-50 of those who are age disputed are actually children, and many of them will be very vulnerable. So we need to make sure there is proper safeguarding in place for this group where there is age disputed. So short time scales for genuine known children, but proper safeguarding where there is an age dispute. There's another concern that's been put to me, that if a child knows that when they turn 18 they could be removed, then as they near their 18th birthday, they may become at increased risk and tempted to abscond from care, often into the hands of deeply worrying people, such as the modern-day slavery that my right honourable friend, the member for Maidstone, speaks about so clearly. Members do need to consider these risks and make sure that in this bill and in the way it is implemented, we're not making vulnerable children even more vulnerable. Thank you.
Liz Saville-Roberts.
And I rise to speak to new clause 1 tabled in my name, which would give those detained under measures in the bill the right to work in the UK after 6 months. And I'm pleased that my amendment has received cross-party support and the backing of the Welsh Refugee Council. Deputy Speaker, words matter, and I do hope to be as balanced as I can in my language, although there is much about this bill that I find utterly abhorrent. Those seeking asylum in the UK are currently effectively banned from working while awaiting a decision on their asylum claims. Permission to work is granted only for jobs on the shortage occupation list, and only after an asylum seeker has waited over 12 months for an asylum decision, providing that the delay was not the fault of the asylum seeker themselves. Once somebody has been granted refugee status, that person then has permission to work in the UK in any profession and at any skill level. This bill does not treat detainees as asylum seekers and states that their asylum claims cannot be considered under the immigration rules. However, the spirit of New Clause 1 is to do away with this false categorisation and to recognise that these so-called detainees are asylum seekers, and in doing so effectively removes the current work restrictions they would face if they were indeed classified as asylum seekers under the bill. This is building on previous attempts to introduce a right to work after 6 months for asylum seekers through proposed amendments in the other place to the Immigration Act 2016 and the Nationality and Borders Act 2022. The present ban means that the majority of people seeking asylum in the UK end up living on £5.66 per day to cover almost all their needs, as they are excluded from mainstream benefits. This places them more than 70% below the poverty line. It cannot be right that asylum seekers are frozen in destitution, waiting months, if not years, while they await a decision. Of the cases in the asylum backlog in the December 22, two-thirds, almost 110,000 people, had been waiting over 6 months, up from 44% of cases in December 2017. This number will only grow as this bill effectively freezes the asylum processing system altogether. Now, if some members here take issue with giving asylum seekers the right to work after 6 months of languishing in unsuitable accommodation and in that poverty, that low paid poverty, then I say to them this: reject this bill, reject it, and instead focus on rebuilding the asylum processing system so that people don't have to wait beyond 6 months to receive an asylum decision. We know that the majority of people who cross the Channel will succeed in their claims to be refugees. And so they will eventually be able to work unrestricted once they obtain their refugee status, providing that their asylum claims have been processed swiftly and humanely. Asylum seekers such as Saeed from Cardiff told me how the ban was affecting them. "I am losing hope," he said. "All I want is a bright future. I am young, I can work, and I am ready to start tomorrow and fund myself." Doesn't he sound like a young Tory? Overturning the ban has widespread public support, with a 2020 petition to the Home Office reaching 180,000 signatories and a 2022 poll showing that 81% of the public supports the right to work for people seeking asylum in the UK. I will, of course, give way.
I thank the Honourable Lady for giving way, and I think she's making an excellent point. And in fact, the government should take this on board, because one of the reasons we are told about wanting to curb this is the cost to the public purse about maintaining people. If they're allowed to work, then we won't have to pay them to be, in fact, in accommodation or have to pay them benefits. So it benefits. It's a win-win situation.
Indeed it is. We know that our economy is suffering from chronic labour shortages, and that, in part, is down to Brexit. Why can we not think out of the box and stop looking at people as a problem and looking at people as part of the solution? I know this very well because Ysbyty Tywyn in my constituency has closed its wards because we cannot get nurses. I represent an area with an older demographic. We cannot get carers. And yet, what are we now? A week away from the local elections in England, and this is what we're talking about. We are not thinking sensibly in the 21st century. Meanwhile, of course, highly skilled asylum seekers are sitting idle in detention centres, eager to work, keen to contribute to our society, but banned from doing so. There are 1.2 million job vacancies in the UK. Businesses are crying out for workers. 70% of businesses want to give asylum seekers the right to work after 6 months. New Clause 1 allows those people detained for 6 months or more to apply for permission to work, including self-employment and voluntary work. This could do so much. This could be such a boost for our economy, and we are suffering, as I said, after Brexit. This right to work is a fundamental human right, and it's crucial for the well-being of asylum seekers and their integration into society. It is also beneficial for the economy, as businesses want to be able to access the skills and experience of asylum seekers. I call on the government not to look at asylum seekers as a political threat, but to look at asylum seekers as this is the thing that the United Kingdom is proud to do well. Yeah? Proud to do well and proud to hold our heads up high within the global order. We are proud of that, and that these people are a potential. People are a potential. They always are, and people are not a threat. And we should be working with that potential as best we can.
Laura Farris.
Thank you, Mr Deputy Speaker. I spent considerable time in the last debate addressing the European Convention on Human Rights, and the House will be relieved to hear that I'm not going to do the same thing again. But I will just say one thing. The Honourable Member for South Holland and the Deepings is correct. We have no say over who sits in the European Court of Human Rights, but no MP has any say over who sits in the Supreme Court of this country either. And the reason why nobody is able to give me an example of the European Court interfering with a material change to our domestic immigration laws is because there isn't one. But just in the time that I have, I did want to congratulate the government for reaching an agreement with the member for East Worthing and Shoreham on New Clause 8, which I think gives the bill moral clarity. The aim of this bill is to extinguish a route, not a right. The bill says that if you enter the United Kingdom by small boat or any other illegal route, you cannot claim asylum now or forever, but we are only maintaining compliance with our legal obligations under the Refugee Convention when we can say in parallel that there are safe and legal routes which you could and should have taken as an alternative. It was already clear that this was envisaged by the bill because it's dealt with in the provisions in section 51 in the context of annual quotas agreed in conjunction with local authorities. And it is plain that this is the direction that not just the United Kingdom, but all our European neighbours are moving in, faced with the mass migration flows of the modern day that simply could not have been envisaged when the Refugee Convention was drafted. Now, of the other amendments I wanted to talk about, new clauses 22, 19, 23 to 25, My first observation is how closely they resemble laws that were tried and ultimately failed by the last Labour government. And that's not me scoring a political point, because I think this is difficult stuff. But a lot of this is in the Nationality, Immigration and Asylum Act 2002, the Asylum and Immigration Treatment of Claimants Act 2004, but it never really worked. And here's why I say it is important today. I want to talk about identification documents, mobile phones and age verification, all of which I have experience of in the immigration tribunals. All of these things boil down to one critical principle, that he who asserts must prove. I refer the House to the evidence of Dan O'Mahony, the clandestine Channel threat commander, who appeared before the Home Affairs Select Committee actually numerous times, but in September 2020, he was asked about the method of arrival, and he said, talking about small boat arrivals, "I can't give you an exact figure, but I can tell you almost none have identification documents. Very, very close to none. Generally speaking, encouraged by facilitators, they get rid of any sort of documentation, phones, ID cards, SIM cards, anything, before they're intercepted by border force. They literally arrive in the clothes they are wearing." And I invite the House to contrast that with Operation Pitting, when every single person who left Kabul at haste in the summer of 2021 arrived in the United Kingdom with a form of identification document. The lack of identification documents is a major problem for the Home Office. It makes them entirely reliant on interviews, trying to ascertain background facts and language tests, but the best that it can do is guess whether a claimant is genuine, and that, I have to say, it leads to a lot of economic migrants being given asylum when they probably would not have proved their case if they had documents. It's contributed to a huge degree of abuse in the system. And the same principle, I think, applies in relation to requiring mobile phones. In an era of mass technology, where smartphones are as commonplace in sub-Saharan Africa as they are in London, when 5 billion people use social media, it must be right that an individual who does not give access to their phone that a negative presumption is reached about anybody who does not hand over access to their phone as a way of establishing their identity. And then the final point I wanted to address is age verification. I dealt with this again and again and again in the tribunal, in the appeal tribunal, in the High Court. It is not good enough to rely purely on the Merton compliance test. Until very, very recently, we have had no scientific method by which to establish the age of somebody. Of course, small children don't go through that, but the vast majority of children coming are all claiming to be around 17. We do now have the technology that allows it. I'm afraid it cannot be left as a matter of discretion or an option for the applicant. If they say they are under the age of 18, they must, as these new clauses require, be obliged to undergo proper age verification.
Thank you, Mr. Deputy Speaker. Before I begin, I'd like to direct the House to my entry in the Registry of Members' Interests for the support I receive from the RAMP project. I'm speaking in support of amendments tabled by my honourable friends for Streatham, Poplar and Limehouse, Walthamstow and Kingston upon Hull. Amendments that attempt to mitigate the damage this bill will do to some of the most vulnerable people, requiring reports on how it will affect those who are pregnant, those who are victims of modern slavery, how it will affect the human rights of refugees, and how it will affect their health too. New Clause 2 and 3 would safeguard pregnant women and girls from removal. I've spoken to those working on the front line in detention centres, feeling deeply uncomfortable and ill-equipped to deal with the idea of pregnant women in these settings. So these amendments are vital. In fact, they give every woman who arrives a pregnancy test on arrival, because they recognise that where they're working is not appropriate for pregnant women. New Clause 4 would provide support for young people under the age of 18 in their interaction with the asylum system. This stands in stark contrast to the government's obsession with trying to discredit and dehumanise children, either by putting forward bogus scientific assessments to determine their age, or bizarrely claiming that they are granting safety to children is some sort of pull factor. And I say that as a biomedical scientist. Lobotomies were well widespread across the globe. That doesn't mean that they were scientifically valid and accurate or even moral. Just because someone's doing it elsewhere doesn't mean we have to do it here. Mr. Deputy Speaker, especially when the evidence is so poor on their accuracy. Mr. Deputy Speaker, it is a damning indictment of this bill that my honourable friends have needed to move this extensive list of new clauses. The protections they attempt to introduce are outstripped only by the litany of rights this government are attempting to remove from some of the most vulnerable people in the world. These are contemptible proposals that have been tabled for entirely cynical reasons. They say they want to stop the boats. We all want to stop the boats, Mr. Deputy Speaker. But when they say stop the boats, it's not because they want to end the crisis in the Channel. It's not because they want to have safe borders where people do not die on them. It's because it's not because they want to end the suffering of people who are trying to come here to claim asylum. It's not even because they want to end the horror of people drowning as they attempt to reach refuge in the UK. It's because they are intent on vilifying people who have survived some of the most harrowing and very worst things human beings can go through. And I know that because I've spoken with many, many refugees and asylum seekers who've come here on boats. That's because on these big issues, Mr. Deputy Speaker, they have no answers. So they're resorting to scapegoats. It is clear that this has been an agenda long before this bill has been presented. And it's clear that the government is being pushed around by a very, very small and extreme group within the Conservative Party. Just look at Government New Clause 22. The amendment shamefully bars UK courts from interim measures to stop someone from being deported if they bring a legal challenge. The government claims that they're considering fairness and the rule of law and that that's a key British principle and a British value. Well, this sheds that. Yet they were only too keen to undermine these principles if it helps them in the scapegoating of the most vulnerable. They want to bypass the European Court of Human Rights and harm Britain's standing in the world, eroding the foundations of international refugee systems and the Refugee Convention, all to appease backbenchers and throw red meat to a small portion of their base.
Would the Honourable Lady give way?
Yes, thank you.
The Honourable Lady is making an excellent point, and would she agree with me that part of all of this dog whistle politics is what the Conservative Party Deputy Chairman said, that the next election is going to be fought on woke, culture, trans issue, and of course stigmatising refugees is part of that.
The Honourable Member makes a very good point. And I think it's worth reflecting in this week alone. We've seen the horrifying news that has reached us about Sudan and the horrific circumstances that not only British and dual nationals are facing, but everyone in Sudan is facing. And while Britain are working hard to evacuate our own citizens, we're not talking about safe routes for Sudanese refugees. We're not talking about our Home for Sudan schemes. No dedicated resettlement routes. No numbers confirmed about what countries the UNHCR should be prioritising in trying to help with what the Minister was outlining earlier. Even the government NC8, the best this bill could offer is a commitment to a report on safe routes, but no actual tangible commitments to open new ones. What are the people fleeing war and persecution in Sudan or anywhere else supposed to do with that? By the time anything comes from this report, it'll be too late for them. They'll be on their way. Mr. Deputy Speaker, the amendments I cited earlier have been tabled because no serious attempt has been made in this bill to ensure that vulnerable people are protected. That's been outlined very well in the discussion that we've had around modern slavery, so I won't add to that. The purpose of this is the complete opposite of providing safe and legal routes for people to claim asylum. It's at its core, these proposals aren't about helping anyone or making anyone safer, not making our borders safer. They're simply about attacking the rights of refugees for the sake of electoral expedience and managing unruly government backbenchers. At the centre of this is a paradox. How can you claim asylum if you're not on UK soil and you have to be on UK soil to claim asylum? How can you take a safe and legal route if there is no safe and legal route that works for you or is available to you? How can you claim safety in the first country that you get to if that is a country that persecutes you because you are LGBT or because you have a disability or religion?
Sir William Cash.
Mr Deputy Speaker, thank you. I want to just start by asking a big question, which is, what is this bill ultimately going to achieve? And the position is really this, that when the European Convention on Human Rights was brought in, we're talking about in the 1950s. I absolutely would have agreed with every word it was said in its application to the Holocaust and to genuine refugees. But what we've witnessed recently has been a phenomenon which has been this small boats problem, and it doesn't just affect the United Kingdom, it affects Italy, and I gather Madam Maloney is coming over to see the Prime Minister tomorrow, and she's certainly going to have something to say about that. The problem is endemic, and it has to be dealt with. I now move to the question of how you do it. You have to pass an Act of Parliament. That's what we're doing now. The third question is, what is the impact of parliamentary sovereignty on the questions of the interpretation by the courts of Acts of Parliament? In the Human Rights Act, when I was in the House in 1998, in fact, as it happens, the Conservative Party voted against the second reading of the Human Rights Act in 1998, which people often forget. The reality, however, is that as things have progressed, we need to bear in mind what, for example, Jack Straw said, and I'm speaking now to the Labour front bench, where he talked about the importance of the sovereignty of Parliament, which was one of the profound strengths of our system, he said, and he referred to it as the fundamental position established in our Constitution. Derry Irvine said much the same in the House of Lords. The reality is that the sovereignty of Parliament is not just confined to the European Union question, it also applies to the human rights questions, and the Labour Party were absolutely explicit about that at the time. The position is that by the end of the legislation, when it was passed eventually, we arrived at a point in which the legal sovereignty continued to rest with Parliament, and the government, in the words of a Labour supporter, said that they had retrieved the first constitution of democratic socialism by ensuring the sovereignty of Parliament. Now, turning to the questions that we have in front of us in New Clause 17 and 22, this is about restricting interim relief and also dealing with the question of serious harm and its interpretation. The courts, according to Lord Bingham, who by any standards is the greatest jurist in of the last few generations, made it clear in Chapter 12 of the Rule of Law, absolutely explicit. It is not for judges to make law, it is for judges to apply the law as passed by Parliament. And I think that is something we all understand on both sides of the House. So that when we ask the question, what is the manner in which these provisions are going to be interpreted in the courts, I refer now to the New Clause 17, and I'm slightly surprised that at the very end of this debate is the first time that this matter has been raised, because it's about the question of what is or is not to be regarded as serious harm by persons who have been given a third country removal notice, because that's when the crunch comes home in respect of the courts in the application to any individual who is affected by the provisions of this bill. I am 100% in favour of this bill. I actually would have preferred the notwithstanding clause, we all know that, but which goes back actually a very long way in parliamentary drafting tradition. But I am prepared to accept that after a great deal of discussion, the distinctions between what is or is not regarded as serious harm have been set out here by a series of examples which will restrict the courts in the manner in which they can make their decisions on these very, very important questions. I don't have time to go into the detail, but I'd simply say this, that by introducing a measure to restrict interim relief, the bill will make clear to the courts the intention that only in-country claims other than factual suspensive claims should be under the narrow exception which is given by the bill. In other words, where people face a real and imminent risk of serious and irreversible harm in the specific country they are being removed to, this provision will apply and the courts will be restricted in the manner in which they apply that interpretation to the individual in question. This will ensure that all other legal challenges must be what's called non-suspensive. In other words, the courts can still hear an individual's case out of country.
Oh, sorry, time's up. Patrick Grady.
Deputy Speaker, I'm not sure I fully completed my honourable member for Stone bingo card there, but we've certainly got most of the greatest hits. I'm not sure if the member for Dover is aware, and I apologise to her if she wasn't, that there was a cross-party delegation of MPs to the Port of Dover last week with the Industry and Parliament Trust. And we learned that in 55 BC, illegal migrants from Rome, possibly led by Julius Caesar, were pelted from the White Cliffs with sticks and rocks. I think it's just as well that none of the ministers from the Home Office were on that delegation, because it might have given them ideas for further amendments to the bill, permitting the throwing of stones at craft attempting to land. Or perhaps they'd be instructing Border Force to seize the Bronze Age boat from the Dover Museum in an attempt to track down any descendants of illegal migrants from 3,000 years ago. We also learned about the Border Force processing facility in Dover, because despite these myths about an invasion of small boats washing up on beaches across the south of England, in reality most small boats are diverted to the port directly from Channel shipping lanes, where of course they are a major risk to larger vessels, and from there people are processed and sent directly to Marston or elsewhere. There is no invasion, there are no thousands of people prowling the streets. There are just human beings so desperate that they are willing to risk their lives to get here. And despite the provisions of this bill designed to be retroactive from the 7th of March this year, according to the Home Office website, there doesn't appear to be any significant change in the patterns of detections since the bill was introduced. So if the bill was supposed to have a deterrent effect, it appears to be failing from the start. But that hasn't prevented the government from doubling down on its hostile environment with a swathe of amendments it has tabled today. During committee stage, the Minister took issue with a number of amendments tabled by my honourable friend from Glasgow Central, saying, at this rate, there will be more SNP amendments to the bill than there are refugees whom they accommodate in Scotland. Instead of pruning the already excessive forest of legal challenges that we find, the honourable member for Glasgow Central proposes a Kafkaesque array of new ones. But now it's the government that's tabling a forest of amendments, with an amendment paper running to 73 pages. And of course, if the government had tabled just one amendment, that would be more than the number of asylum seekers it actually seems to want to accommodate in this country. And if people are looking for Kafkaesque amendments, then they only need to turn to the government's new Clause 26 and consequentials. Picking and choosing which parts of the ECHR it wants to apply at any given time betrays the true agenda of the Home Secretary and her cheerleaders on the Tory backbenches to take us out of European and eventually global human rights frameworks altogether. And the same applies to their amendments which will undermine their own previous legislation on human trafficking and modern slavery. And these will be counterproductive. As the Trade Union Congress has said, the proposals would mean modern slavery victims who are trafficked for exploitation are first denied refuge, then returned to their country of origin, back into the hands, almost certainly back into the criminal gangs who trafficked them in the first place. And where the government have been forced into making concessions, these are nowhere near adequate. I've heard from many constituents in Glasgow North who want refugees to be welcomed here, to have the right to work so they can contribute to our economy and society, as Plaid Cymru propose in New Clause 1, and to be able to come here by defined, safe and legal routes that are established and workable, not a vague pledge to publish a plan about a review, about a consultation in a few months' time, which is what's suggested in New Clause 8. In fact, what constituents in Glasgow North want to see is the bill defeated at third reading and scrapped altogether. And failing that, the government should adopt the wide range of amendments tabled by the SNP, which aim to bring at least a vestige of humanity into the system, which is what Amendment 45 would do by requiring courts to make sure the Act is interpreted in line with our international treaty obligations and make sure that it still resembles an asylum process rather than a deportation charter, which is also why we've tabled Clause 46 to delete Clause 2 in its entirety. I've asked in this House before, how often have Home Office ministers or their Farageist fanboys on the back benches actually sat down with asylum seekers, people who've come here on small boats, and listened to their stories? There's an open invitation to any of them, front and back benchers alike, to come to Glasgow North and meet the inspiring members of the Maryhill Integration Network, who have come here fleeing war and persecution, and who, despite being met by the most hostile of environments created by the Home Office, are determined to make a new home in Scotland and make our society a better place for everyone to live. And that's what an effective asylum system should be designed to produce. People in genuine need, supported and welcomed to rebuild shattered lives and strengthen our society as a whole. The government amendments today to an already inhumane bill move us further away from that ideal. But it's an ideal that constituents in Glasgow North and across Scotland will continue to aspire to, and which will be the foundation of our own independent asylum and immigration system when Scotland too breaks free of the UK's hostile environment.
Trigger.
Thank you very much indeed, Mr. Speaker. I'm very pleased to have listened to this very, very interesting and useful debate. And I rise to speak to new clause 22 and new clause 17, which clarify the means by which a suspensive claim may be made to stop a removal from this country. And in this context, I want to briefly reply to my honourable friend, the member for Newbury, who's made a very good speech in the committee stage of this bill, opposing the amendment that I tabled at that stage, which sought to disapply the operation of the European Convention on Human Rights as a means to prevent removals. And her point then was that the English law already included protections which could be used in the same way as the ECHR. And of course, she's quite right. The jurisprudence of the UK does have a set of remedies against unfair treatment, and these still apply. And indeed, they are clarified in this bill. The contradiction to what the Honourable Lady opposite was just saying, the remedies for a suspensive claim against a removal are clarified in this bill, and particularly the principle of non-refoulement, which is in our common law. Even without European rights law, we would have that. And so this policy does not contradict that principle. Indeed, it strengthens it with a clear protection for people who would suffer harm by being returned to their own country, or indeed any country. And now that that relief is in there and clarified, we need to block the spurious use of other domestic remedies which are no longer necessary. I want to thank the Minister and the team for their very constructive engagement. I'm very happy with where we've got to in this bill, and I want to quickly explore the issue at the heart of this debate, which is not really about migration, but about the sovereignty of Parliament to make the laws, including over this essential issue. And it's been established in recent times that, particularly in the judgment in Thoburn in 2002, that some laws in this country have more weight than others, and indeed are not subject to implied repeal. They essentially have the status of constitutional documents. And of course, the European Communities Act had that status until Brexit. And the other act which has this constitutional status is the Human Rights Act, which requires and enables British courts to apply the ECHR. Now that doesn't have a doctrine of implied repeal over it either. And of course, the Human Rights Act requires the courts to follow the judgments made in Strasbourg. Now, Mr. Deputy Speaker, I can live with anomalies. We don't want a hasty, destructive, ideological or populist rejection of the status quo of the legal arrangements of this country. That's not the British way. It's not the Conservative way. We can live with an eccentric inheritance from the post-war era. The problem is when it's not eccentric, but when it's deeply problematic, as it was in June last year, when the European Court put a stop on our removals policy, and that, in response to my honourable friend, is an occasion on which the European Court exercised an interference in our immigration policy. Now, I accept that that was just a rule of the Court, which in my view we could have ignored, but the government seemed to accept the legal advice that it was obliged to give immediate effect to that ruling. So I'm very pleased that we have new clause 26, which gives the Home Secretary the power to disregard Rule 39 interim orders from Strasbourg, but we still remain subject to Article 46 of the Convention, which obliges us to comply with final judgments. And for me, there are two profound problems with our membership of the ECHR. The first is that we have an inbuilt ratchet with Strasbourg rulings. Their treatment of the ECHR as a living instrument to be interpreted in the light of whatever cultural ideas are prevalent or appealing to the judges. And thanks to the Human Rights Act, these rulings form part of English law. And at the same time, we have a willingness among lawyers here in the UK to employ the ECHR to frustrate the will of Parliament, to refer the laws that we make to some higher authority, to an abstract morality rooted not in custom or in the habitual allegiances that we have to each other as citizens of the same country, but rooted in their own liberal fantasies. Now, Mr. Speaker, I also believe in a higher authority and one which respects the dignity and value of every human being. Let's call it the natural law. I believe that this higher authority is indeed the source of all our liberties and rights, and indeed of the ECHR and of every other noble-sounding document in the West. It's the source of our morality, but the way this morality works out in practice is not through abstract theorising from on high. It works through the accumulation of case law and of the statutes passed in this place. Now, I'm not proposing that we come out of the ECHR now. I'm suggesting that if there is a further challenge to British sovereignty and the supremacy of Parliament, whether in Strasbourg or the British courts applying the Convention, then we have no superior obligation to remain in it. The superior obligation is to our own sovereignty and the supremacy of this place. This debate has exposed a difference between those of us who believe in nation-states and in the customary laws of nations versus those who believe in abstractions to be interpreted by unaccountable judges, whether in their pyjamas or not. I'm very content with where we've got with this bill, and I support it unreservedly.
Minister to respond to the debate.
Well, thank you, Mr. Deputy Speaker, and I want to thank and commend the Right Honourable and Honourable Members on all sides of the House for what has actually been a very measured and thoughtful debate over the course of this afternoon. The bill before us today is probably the most significant immigration bill in my lifetime, and for that reason, it's important that we get it right. The debate today has centred on a number of significant issues, and I won't reprise all of my remarks earlier, having spoken for the best part of 3/4 of an hour and taken many interventions, but I will touch on the 5 principal areas that were discussed on both sides of the House and attempt to provide any further reassurance that's required. The first significant issue was around the removal of minors. And as I said earlier, the approach of the government with respect to children is one where we take the interests of the child extremely seriously. These are morally complex issues, and myself and all of the ministers involved in the preparation of this bill have thought very carefully about how we can protect children, both at home and abroad, in producing this bill and the scheme that belies it. The ways in which we will approach the removal of children now, I hope, are very clear, thanks to the work that we've done with a number of Honourable and Right Honourable members, including in particular the members for Shoreham and Worthing and the member for Chelmsford. We will only seek to remove those children, unaccompanied children, in exceptional circumstances, and the 2 principal purposes, as we've now made very clear, are for family reunion and for safe return home to the loving care of social services in their home country. With respect to the detention of children, again we've taken this issue extremely seriously because we don't want to detain children. We will only do this in the most exceptional circumstances, and the circumstances that we have now clarified in the bill and in the course of the debate, again with the helpful guidance and support of Honourable and Right Honourable members, are for the purposes of initial processing when children and families arrive in the United Kingdom irregularly in small boats or other forms of clandestine entry. And then for the purposes of removal from the country, again, those purposes being the very limited and defined ones I mentioned a moment ago. We understand the desire of many people across the House that there are carefully thought through and limited time limits upon that detention. And the amendment that we've brought forward and the remarks I've made today, I hope give reassurance that we will bring forward that regime and that it will be as short as practically possible. There is a significant exception to that rule, and that is, of course, for those cases where there is a serious age assessment dispute. And here, the undoubted desire to limit the amount of time that a child is ever detained by the state has to be balanced against the equally important safeguarding issue of young adults, indeed not all so young as the right honourable gentleman, the member for South Holland and the Deepings, mentioned earlier with regard to the recent allegation of a 42-year-old posing as a minor, we have to get the balance right so that those young adults are not regularly posing as minors and creating an enormous and very concerning safeguarding risk for our young people. I'll give way to the honourable gentleman.
I simply rise to say this, that the engagement we've had with him and his department throughout this process has been exemplary. It's been a model for how good scrutiny can improve legislation. I want to thank him, and in particular the Home Secretary, for the stand they've taken.
Well, I'm grateful to my right honourable friend and return the compliment that it is important that we in government listen to the expertise that we have on all sides of the House, and I hope that members will agree that that's the approach that we're taking to these sensitive issues. Age assessment certainly is one of those, because I don't want to see a situation where on a regular basis young adults are coming into the UK illegally, posing as children, and then those people are ending up in our schools, in foster care families, in our unaccompanied minor hotels, living cheek by jowl with genuine children. That is an evil that we have to stamp out, and the approach that we're taking in the bill will help us to do so. The third issue that was the subject of debate, and again I think of a high degree of unity, certainly on this side of the House, but perhaps more broadly, is the approach now to safe and legal routes. We want to stop the boats. We also want to ensure that the United Kingdom continues to be one of the most respected countries in the world for the way in which we provide sanctuary to those people who are genuinely in need. We're doing that already, as evidenced by the fact that since 2015, 500,000 people have come into our country legally on humanitarian grounds. We have safe and legal routes today, but I appreciate the views of a number of honourable and right honourable members, including, most notably, my honourable friend, the member for Shoreham and Worthing, and that has led us to the agreement that we will rapidly bring forwards the consultation with local authorities that grounds the desire of this House to be generous with the reality on the ground of our communities and councils, and that within 6 months we will bring forward the report that's the result of that, and over the course of next year, as soon as possible, we will set up or expand the existing safe and legal routes so that the UK can be an even greater force for good in the world. Well, I hear the honourable lady laughing at that. Of course, Scotland could step up to the plate as well. And since she tempts me, I would just say that her and her colleagues asked for an extension to this debate today, and then as far as I'm aware, only 2 spoke in the debate. There were fewer SNP members speaking in the debate than could fit into Nicola Sturgeon's battle bus. I'll happily give way to the honourable lady.
That the other SNP members had put their names in for this debate because the debate was originally scheduled for Tuesday and the government changed the timing at the last minute.
Oh, well, I do find that rather unconvincing, given that so many were able to turn up earlier, and it does rather reinforce the point that the Scottish National Party's approach to these issues is entirely performative. They talk the talk, but they don't act. On this occasion, we didn't even get the talk. I won't give way to the honourable lady. Now, and the fourth serious issue that was raised was the one principally by my right honourable friends, the members for Chingford and Woodford Green, and the right honourable lady from Maidenhead, with respect to our mutual desire for the good work that they did in office to establish our world-leading modern slavery framework, to live on, to continue to support genuine victims, and in particular those victims of modern slavery who've been in the United Kingdom for a sustained period of time and have been the subject of exploitation here, rather than in the course of their passage, whether that be in a small boat or otherwise. And whilst it's clear that we are not able to settle the matter today, I do hope that my right honourable friends, in fact they said so in their remarks kindly, will work with the government in the course of the continued passage of the bill to ensure that we get the balance right. I'll give way to the right honourable, but sorry, he corrected me earlier, the honourable gentleman.
It's very brief. Can I just suggest that he doesn't move that Amendment 95? I think the House isn't in favour of it. It'll end up being removed in the House of Lords. It would satisfy both the members who are both nodding behind him if he just didn't move it.
I'm not going to do that, but I thank him for the advice. The amendment to which he refers enables the government to ensure that those individuals who are the subject of a police investigation or participating in a police investigation with the aim of bringing their traffickers to justice can have that investigation conducted in the United Kingdom, or if it is safe to do so, to have their contribution to that investigation conducted whilst in a safe third country like Rwanda. Well, I'll give way to the right honourable lady, of course.
Friend, he has been very generous in giving way, and I must apologise to the Home Secretary because I think I referred to the Immigration Minister as Secretary of State earlier on in the debate. What Amendment 95 does is not say that people who are here and participating in an investigation can actually be here in the UK and enabled to continue to take part in that investigation and provide the evidence. What it says is the assumption must be that they will be removed from the United Kingdom, and it is only if the Secretary of State reads her own guidance on compelling circumstances that she will enable them to stay in the United Kingdom. It has reversed the original subsection 5 of clause 21. So it's gone back on what the government originally said they were trying to do.
The right honourable lady doesn't, I think, agree that Rwanda is a safe place for those who are victims of modern slavery to be supported. But the critical point here is that, of course, we want to support those individuals, and we have no intention of removing them, whether home to their own country or to a safe third country, unless that is a place where there is sufficient safeguards to ensure that they are protected. That's the nature of the agreement that we've struck with Albania, and that's the nature of the agreement that we've struck with Rwanda, which was upheld by the High Court, and of course we hope will be upheld by the Court of Appeal. It is natural, therefore, that in many cases individuals can go to those countries and participate in any law enforcement activity from there. I won't give way to the honourable lady, but I thank her for her suggestions. The last issue that was the subject of the debate was obviously those questions raised by the honourable members for Stone, for Devizes and for others about how we strengthen the bill, and in particular the question around interim measures. I'll say again, as I said in answer to the right honourable gentleman, the former Attorney General, the member for Devon, that of course this ministerial discretion will be exercised judiciously and in accordance with our treaty obligations. We take international law and our treaty obligations extremely seriously. Now, Mr. Deputy Speaker, I won't dwell on the Labour amendments today because as at committee stage and as at second reading, they pose no credible policy to stop the boats whatsoever. The truth is that tweaks to our system will not suffice. In an age of mass migration, only a significantly more robust approach can end the injustice of illegal migration. The totality of Labour's policy on illegal migration is to accept more people into our country and to do so as quickly as possible. That is weak. It's also, frankly, dangerous. And we've yet again seen today that Labour is decades behind when it comes to illegal migration. They're 20 years behind the views of the British public. They're 20 years out of date with their policy proposals. But perhaps this comes as no surprise when they're being led by someone who their own colleagues say should have left politics 20 years ago. One briefed the papers that she knows where the door is. Given Labour's record on immigration, we can assume that it's an open door. But whilst Labour are fighting each other, the Conservative Party tonight has been united. We are united in fighting the people smuggling gangs. Only the Conservatives are taking the tough but necessary action to stop the boats, because it is only this party that is ultimately on the side of the British public. As my right honourable friend from South Holland of the Deeping said, from Worthing to Walthamstow, the British people want to stop the boats. And the only way to stop the boats is to sever once and for all the link between crossing the Channel illegally and being able to live and work in the United Kingdom. And that, at its heart, is what this bill does. Nothing else will cut it. We have tried it all before. The British people demand that we stop the boats, and only the Conservative Party will do so.
Thank you very much. Now then, before I start posing the questions, maybe I can help with a little bit of process here, and that is that I am anticipating 5 votes between 6 and 7. The first vote will clearly take 10 minutes, but every subsequent vote thereafter will be 8 minutes. So my strongest advice to everybody is to stay within the parliamentary estate in order that the votes can be taken as efficiently as possible. Because of the number of votes, I will put the whips in, the tellers in rather, as quickly as I possibly can. So order, order. Under the order of the House of the 13th of March, I must now put the questions necessary to bring to a conclusion proceedings on consideration of the bill. The question is that new clause 17 be read a second time. As Minister and say aye. Aye. No, I think the ayes have it. The ayes have it. The question is that new clause 17 be added to the bill. As Minister and say aye. Aye. No, I think the ayes have it. The ayes have it. The question is that government new clauses 19, 20, 23, 24, 25, 26, 22 and 8 be added to the bill. As many of that opinion say aye. Aye. Contrary no. I think the ayes have it. The ayes have it. Now, we come to new clause 9, which has been selected for a separate decision. And is it Mr. Kinnock to move?
Formally.
Formally, thank you. The question is that new clause 9 be added to the bill. As many of that opinion say aye. Aye. Of the contrary, no. Division, clear the lobby. Order. The question is that new clause 9 be added to the bill. As many of that opinion say aye. Aye. Of the contrary, no. Tell us for the ayes, Mary Glinton and Gerald Jones. Tell us for the noes, Amanda Soloway and Robert Largan. Order. Order.
The ayes to the right, 233. The noes to the left, 285.
Thank you. The ayes to the right, 233. The noes to the left, 285. So the noes have it, the noes have it. Unlock. Right, we're now coming to new clause 10, which has been selected for a separate decision. And I call Mr. Kinnock to move.
Formally.
Move formally. So the question is, the new clause 10 be added to the bill. As many of that opinion say aye.
Aye.
On the contrary, no.
No. Aye.
Division. Clear the lobby. Order. The question is that new clause 10 be added to the bill. As many of that opinion say aye. Contrary, no. Tell us for the ayes, Gerald Jones, Mary Glindon. Tell us for the noes, Amanda Soloway and Robert Largan. Order! Order!
The ayes to the right, 231. The noes to the left, 290.
Thank you. The ayes to the right, 231. Noes to the left, 290. So the noes have it, the noes have it. Unlock. We're now coming to new clause 15, which has been selected for separate decision. I call Mr. Kinnock to move.
Formally, sir.
The question is that new clause 15 be added to the bill. As many of that friends say aye. Aye. No. Division, clear the lobby. Order, order. The question is that new clause 15 be added to the bill. As many of that opinion say aye. Aye. On the contrary, no. Tell us for the ayes, Gerald Jones, Mary Glindon. Tell us for the noes, Amanda Soloway, Robert Largan. Order. Order.
The ayes to the right, 219. The noes to the left, 284.
Thank you. The ayes to the right, 219. The noes to the left, 284. So the noes have it, the noes have it. Arnold. I call the Minister to move amendments 111 to 113 and 77 formally.
Move formally.
Move formally. The question is that amendments 111 to 113 and 77 be made. Has been another say aye.
Aye.
No, I think the ayes have it. The ayes have it. We now come to Amendment 45 to Clause 1, which has been selected for separate decision, and I call Alison Thewlis to move the Amendment 45 formally.
Move formally, Mr.
Formally. The question is that Amendment 45 be made. Has been another say aye.
Aye.
No. Division. Clear the lobby.
Good. She lived in Lancaster and got Smith offered her a job, so I lost her. Oh yeah, I know. I thought you might take it.
Order. The question is that Amendment 45 be made. Has Mayor Levin say aye?
Aye.
Contrary, no. Tell us for the ayes, Peter Grant, Marion Fellows. Tell us for the noes, Amanda Soloway, Robert Largan. Order. Order.
The ayes to the right, 231. The noes to the left, 290.
Thank you. The ayes to the right, 231. The noes to the left, 290. So the noes have it. The noes have it. Unlock. I call the Minister to move amendments 89, 185, 174, 106 to 110, 175, 176, 177, 79 to 83, 90, 91, 139, 140, 134, 141, 142, and 135 formally.
Formally.
Formally. The question is that amendments 89, 185, 174, 106 to 110, 175, 176, 177, 79 to 83, 90, 91, 139, 140, 134, 141, 142, and 135 be made. As many of that opinion say aye? Aye. We know, I think the ayes have it. The ayes have it. We now come to Amendment 2 to Clause 11, which has been selected for a separate decision. And I call Dame Diana Johnson to move Amendment 2 formally. Formally. The question is Amendment 2 be made. As many of that opinion say aye? Aye. We know. No. Clear the vision. Clear the lobby. Order. Order. The question is that Amendment 2 be made. As many of that opinion say aye. Aye. Oh, the contrary, no. No. Tell us for the ayes, Gerald Jones and Mary Glindon. Tell us for the noes, Amanda Soloway. Robert Largan. Order. Order.
The ayes to the right, 231. The noes to the left, 286.
Thank you. The ayes to the right, 231. The noes to the left, 286. So the noes have it. The noes have it. Unlock. I call the Minister to move amendments. 143 to 145, 136, 146, 147, 137, 148, 149, 86, 150, 87, 151 to 157, 85, 88, 84, 158 to 160, 124 to 131, 95 to 97, 114 to 119, 161, 162, 104, 105, 122, 92, 163 to 169, 123, 170, 171, 33 to 35, 172, 173, 36 to 43, 18 to 32, 186, 11, 178, 98 to 100, 120, 187, 133, 179, 180, 93, 94, 103, 138, 101, 102, 121, 188 and 189.
Move formally.
You're wasted here. I don't care what you say, I'm earning my money tonight. The question is, and here we go again, that amendments 143 to 145, 136, 146, 147, 137, 148, 149, 86, 150, 87, 151 to 157, 85, 88, 84, 158 to 160, 124 to 131, 95 to 97, 114 to 119, 161, 162, 104, 105, 122, 92, 163 to 169, 123, 170, 171, 33 to 35, 172, 173, 36 to 43, 18 to 32, 186, 11, 178, 98 to 100, 120, 187, 133, 179, 180, 93, 94, 103, 138, 101, 102, 121, 188 and 189 be made. As many other say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. I'm glad I got my eyes done. The question is that new Schedule 1 be added to the bill. As many of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. Finally, we come to Government Amendment 78, and I call the Minister to move Amendment 78 formally.
Move formally.
Formally. The question is that Amendment 78 be made. As many of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. Consideration completed. Third reading.
Now.
Under the order of the House of the 13th of March, I must now put the question necessary to bring proceedings on third reading to a conclusion. The question is that the bill be now read the third time. As many of that have been say aye. Aye. Of the contrary, no. No! Clear the lobby. Order, order. The question is that the bill be now read the third time. As many of that evidence say aye. Aye. Of the contrary, no. No. Tell us for the ayes, Amanda Soloway, Robert Largan. Tell us for the noes, Gerald Jones. Mary Glendon. Could resume their seats, please. Order. Order.
The ayes to the right, 289. The noes to the left, 230.
Thank you. The ayes to the right, 289. The noes to the left, 230. So the ayes have it. The ayes have it. Unlock. Point of order, Alison Thewlis.
Thank you very much, Mr Deputy Speaker. We have just passed a bill for which the Home Secretary is unable to make a declaration under the Section 19 of the Human Rights Act that it will be compatible. Others have suggested that it will break the Refugee Convention, the European Convention on Action Against Trafficking, the UN Convention on the Rights of the Child and the UN Convention on the Rights of Stateless Persons. And I seek your guidance, Mr Deputy Speaker. I'm sure that none of our constituents send us to this place to break the law, and it seems to me that we have perhaps done so in voting for the illegal immigration bill. Given that we have a duty in this place, a very special duty to be guarantors of human rights in this Parliament, collectively and individually, can you advise what we might do?
I'd like to thank the Honourable Lady for her point of order and a forward notice of it. I can only respond to the bits for which the Chair is responsible, and I am content that the House has proceeded perfectly properly, but her comments are on the record. Point of order, Peter Grant.
Thank you, Mr Deputy Speaker. Further to that point of order, have you or has Mr Speaker had any contact from the Leader of the House to indicate further in future the intent to allow sufficient time for major pieces of legislation to be properly considered before being forced through?
Well, I'd like to thank the honourable member for his point of order, and I can only speak for myself. I have not spoken to Mr Speaker, but no one has been in touch with me. We'll now go on to motion number 3 on the extension of pilot arrangements. Minister to move.
I beg to move.
The question is as on the order papers. May that say aye? Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to motion number 4 relating to the coronation of His Majesty. Minister to move.
I beg to move.
The question is as on the order papers. May that say aye? Aye. No. I think the ayes have it. The ayes have it. Petition. Andrea Leadsom.
Thank you, Mr Deputy Speaker. The petition of residents of Cyresham and surrounding villages, Crowfield, Pimlico, Biddleston, Houndon, Wapping, Whitfield, Silverstone and Whittlebury, declares that the petitioners object to the construction of a truck stop with a fuelling station on land next to the A43 slip road for Cyresham on the rural B4525. Further declares that its construction would be detrimental to the community, that it would cause difficult traffic issues due to its close proximity to the A43 slip road, alongside permanent ecological and environmental harm, including noise, air and light pollution. Further notes that while residents understand the pressures endured by HGV drivers, they suggest that there are far more appropriate locations in the vicinity. The petitioners therefore urge the House of Commons to work with local residents to ensure this planning application permission be refused.
Thank you. Petition, Cyresham truck stop.
Thank you very much.
I beg to move that this House do now adjourn.
The question is that this House do now adjourn. Mr. Richard Drax.
Thank you, Mr. Deputy Speaker. It's a pleasure to speak in the House tonight, and I'm delighted in particular to see the Minister in his place, with whom I've had a few words. And I can actually apologise to him because he's had a hard day already, but I'm afraid it's going to get even harder in the next few minutes. Stop the boats, Mr. Deputy Speaker. Stop the boats. Following today's debate, the timing of my adjournment debate could not be more apt and ironic. Apt because I wholly support the illegal migration bill and its intent. Ironic, because before there's any chance of illegal migrants being sent to Rwanda or anywhere else, they're being dumped on a barge in my constituency. To be fair, and I try my utmost to be fair, the situation is completely out of control, and tens of thousands of illegal migrants have to go somewhere. However, where they go needs careful thought, consultation, preparation, and then execution. I regret to say that in our case, none of these things have been taken into account. Not one. What has happened is this. Portland Port is approached by the Home Office and sees a commercial opportunity. All negotiations are done in private. None of the statutory authorities are consulted. On the 21st of March this year, the Home Secretary rings me to say that a barge of 500 migrants will be placed in the port. The Chief Executive of Dorset Council has a similar call from Home Office officials. Please note, Mr. Deputy Speaker, we were told the barge was coming, not what's your opinion? How will you cope? What support do you need? Who will provide the health care? What extra funding will be available for the police? What responsibilities will Dorset Council have for the migrants? What appreciation has been done to consider the effect such an influx of young men might have on a sensitive seaside resort? I could go on and on and on. Instead, this contentious plan was imposed on us, with the Home Office now desperately claiming they've consulted widely. True. Realising they've gone about this in the wrong way, they are now calling Dorset Council, the health authorities and the police, but after the decision was made. None of these organisations support the plan, and they've made that very clear repeatedly to Home Office officials, as I have to the Minister and to the Home Secretary. At the first multi-agency meeting, Dorset Council stated its clear position that it was opposed to the proposal, as did health representatives, who raised concerns with Home Office officials about the risk of an outbreak of infection on the barge, the likely and possibility of severe mental health issues, including PTSD, that some of these young men might have. They just do not have the resources to cope. And any effort now by ministers to suggest that these organisations are supportive and helpful is not correct. Dorset Council and statutory organisations are polite and professional, constantly challenging the Home Office for more information, which is frequently not forthcoming. Let me ask the Minister a question. Who are these migrants? Where are they from? Can he guarantee that they have not committed any crime? Robbery, rape, assault, whatever. I'd be most grateful when he sums up that he can guarantee that none of the 506 young men coming to us have committed a crime. I've now received the first answer to many written questions I'm submitting to the Home Secretary. I asked how long individual migrants would stay on the barge. Did they have to be on the barge overnight? Would there be a curfew? And what happened if they did not return? This is the reply I received, and I quote, "The site is self-contained, although those living at the site would be free to come and go. If an asylum seeker were not back on site by 11 p.m, the team would make a call to check on their welfare. This would not be under curfew conditions. It would be based on following up on the safety and welfare of the individual. I'm not sure a migrant who wants to disappear is going to answer the phone. Does the Minister? Were they accommodated in a hotel, as many are now, I can see that an 11 p.m. deadline might just work. But this barge is located in a heavily restricted port. The only way out and back in is via one checkpoint on a bus. So, how many migrants will be allowed out of the port at any one time, there being only one bus? Where will they be dropped, in Dorset or anywhere else? Who will monitor them? How much money will they have? In the summer, the beaches will be packed with families and young people. Have the cultural differences been taken into account? What happens to the hundreds of other migrants still stuck on the barge? How long before there's trouble on the barge? And on the barge itself, can the Minister confirm tonight that it is actually designed to accommodate 222 people? If so, as we believe is the case, how will it house 506 people? That must mean doubling up in the rooms, but that still leaves 62 people without one. Surely this overcrowding only increases the risk of a disturbance. And is it realistic to expect 500 young men to meekly return to their quasi-prison, and that's what it will be, at 11 p.m? Worryingly, both the Police and Crime Commissioner and my honourable friend, the member for West Dorset, who's here tonight, and me, were told by Home Office officials that it was in the migrants' interest to behave, as it would help their asylum applications. So, come to the UK illegally, be a good boy, and you can stay. I hope I'm not being cynical, but that's certainly how it came across. That's going to really deter those wishing to come here. We also heard from the Minister's officials they were considering private healthcare for these migrants. When my constituents struggle to actually see a doctor and hunt for a dentist, I'm not sure they will understand why those who have come here illegally should have preference. Although the port is no longer a naval base, it is still home to RFAs and accommodates visits from HM ships and nuclear submarines. So I asked the Minister, to what extent has the MOD been consulted on the impact of this barge, including on emergency planning arrangements under radiological protection legislation, evacuation measures, and site security? And on a similar vein, where is the Home Office risk assessment that I assume the Minister and his team have completed? If so, where is it? Now, the police, who do not support the barge either, have calculated that enhanced community policing will cost about £700,000 a year. Who will meet this cost? Dorset Police already struggles financially, it being the second worst funded force in the country. As our PCC, David Sidgwick, said in a letter to the Policing Minister, and I quote, "It is disappointing that there was an absence of community or stakeholder consultation prior to the site proposal being launched. And I note the impact upon public trust and confidence resulting from that omission." He went on to say, and I quote again, "This means that without prior knowledge of the intent, there has been no planning at all in regard of policing resources." As the Minister well knows, Weymouth is a sensitive, family-based seaside resort. Hoteliers, B&Bs and other small coastal businesses rely almost entirely on the summer for their revenue. As far as I know, no thought, or certainly no evidence of it, has been given to the impact this large influx of migrants might have on them. Now, the Minister, who sits here in the House tonight, told me on Monday evening that the Home Office had consulted widely. His interpretation of consultation is very different from the Council's. Now, I've asked the Council for a schedule of meetings in order to check the facts. As I've said, the Council and I were first told about the barge and that it was coming on the 21st of March. On the 27th, the Chief Executive of Dorset Council, Chief Executive of Portland Port, and Home Office officials had their first initial conversation about the proposal. This was 10 days after the Ports Board gave the project the green light. At the first multi-agency meeting on the 29th of March, Dorset Council stated very clearly it opposed the plan, as I've already said. Since then, there's been about 10 virtual meetings of one kind or another. In response to all these meetings, Dorset Council said to me, and I quote, "As with all these meetings, our attendance is in the main to seek to gain answers to questions that to date have either not been answered or have not been answered with enough details to be meaningful. Our attendance should not be characterised as taking a supportive position, but one of inquiry to gain facts." What is clear, Mr. Deputy Speaker, is that the Home Office had made its decision before consulting with anyone other than the port. Now, bombarded by questions it cannot answer and opposed by all the statutory bodies, the Home Office is trying to smooth troubled waters. Regrettably, diplomacy is not the Home Office's strong point, and a lot of goodwill has been squandered. It's been handled in the most discourteous way, and I'm afraid the Minister has not exactly covered himself in glory either. As I understand it, a contract has been signed, and we'd like to know when. Officials told us that withdrawing from it now would be a breach of contract. So the Home Office has dug itself a hole, and worse, given Dorset Council no other option but to consider taking legal action. We know that the contract is for 18 months. However, the Home Office website states this will be kept under review, which is pretty open-minded in my view. And bearing in mind the scale of the problem nationally, I fear this barge could be in place for years to come. The website also explained why Portland Port was chosen. And again, I quote, "This site will create new jobs and will bring investment into the area." What jobs, Minister? What new investment? The likelihood is going to bring trouble. Personally, I have received no information whatsoever from the Home Office, other than you're getting a barge. If the Minister just listens for 1 second rather than interrupting again, back on the 21st of March, the Minister did offer a meeting, but I was in no position to accept the invitation without consulting all those that the Home Office has singly failed to consult. This is an unholy mess, not totally of the Minister's doing, but the way this proposal has been forced on us certainly is. I can only hope that our plans to deter illegal migrants can be enacted soon. Most importantly, this will save lives and counter the trafficking gangs who ply their vile trade. In the meantime, I advise the government to start building secure reception centres, and fast, as this problem is not going to go away, and placing them on barges in very sensitive ports like mine is certainly not the answer.
Minister.
Well, thank you, Mr. Deputy Speaker, and I'm grateful to the honourable gentleman for securing this debate. I'll come on to the specific points he raised in relation to his constituency in a moment. There is, of course, an important local dimension to this matter, and the Home Office is acutely aware of this, and I will set that out. But I do think it's important at the outset to briefly set out the national context. The situation in the Channel has placed the UK's asylum system under unsustainable pressure. The rise of illegal and dangerous and wholly unnecessary small boat crossings has left us in the invidious position of having to accommodate over 48,000 individuals in hotels at eye-watering expense to the taxpayer. It's simply wrong that British taxpayers are footing the bill of almost £2.3 billion a year to accommodate illegal migrants. And these hotels are valuable assets which are being taken away from communities and placing pressures on local public services. The public are quite rightly demanding that we grip this problem and that we end the use of the hotels. The enduring solution is to stop the boats, and that is what we are focused on. We've introduced the Illegal Migration Bill, which goes further than any previous immigration legislation to fix this problem. And we've substantially increased illegal working raids and returns. We've elevated our cooperation with France to unprecedented levels to drive up interception rates and arrests. But as I've said before, we must suffuse the entire system with deterrence, and this includes our national approach to how we accommodate illegal migrants. In the short term, that means switching to cheaper and more appropriate forms of accommodation, such as disused military sites and vessels. Such measures are in keeping with action being taken across Europe, with France, Germany, Italy, Ireland, and the Netherlands all taking similar steps. The UK can't risk being left behind and becoming a magnet for millions of people who are displaced and seeking better prospects. These alternative sources of accommodation, including the one we will locate in the Honourable Gentleman's constituency, are therefore undoubtedly in the national interest. The Home Office is determined to work closely with the Honourable Member and key local stakeholders to ensure that the site in his constituency at Portland Port is delivered in a way that minimises the impact on the local community. We understand entirely the concern that his constituents will feel and that he is articulating this evening, and want to ensure that wherever possible we allay those fears in the weeks and the months ahead, and certainly to do as much as possible in advance of the arrival of the barge at Portland Port later this year. When looking at proposals for new sites, the Home Office does take into account the impact on the local community, and that's why we're working now with local partners through the multi-agency forum that the Honourable Gentleman referenced, and holding regular meetings with representative groups within the community. I'll happily give way.
I'm grateful to the Minister to give way. Not an easy one for him, I know, I appreciate. As he just rightly said, they are now talking to all the bodies they should have been speaking to. That's not the point. The point I'm making, all this should have happened before he imposed this on us, because at least then we could have had an honest and frank conversation as to whether this migrant barge was possible to cater for, look after, and deal with all the issues that I've raised in my speech. That has not happened.
Minister. Well, I hope that in the time I have available, and I appreciate that that isn't a great deal, I can answer as many of the questions that he's raised as possible. I would say that as soon as it became apparent that Portland Port could provide the support required, and before a contract was signed or a decision made by the Home Secretary, Home Office officials did reach out to Dorset Council, and they had an initial meeting with the Chief Executive on the 21st of March. The multi-agency forum that we've both referenced met on the 29th of March and has met at least 4 times since then. These forums are a way to bring together the public and community agencies, including the NHS, the police, emergency services, alongside elected officials like town councillors and residents' groups. We at the Home Office certainly will do everything we can to ensure that process is as successful and as constructive as possible, accepting that many of those stakeholders and indeed residents will come to those meetings from a position of either strong opposition or preference that we were not proceeding in the first place.
I'm grateful to Mr. Giveaway. The reason they object, Minister, is simply because we don't have the resources to cope with this. You are putting a potential landmine into a highly restricted port with young men trapped in a barge for many hours a day, with a few being let off God knows where. Where are they going to go, Minister, What are they going to do? What happens if they don't come back? A telephone call? I hardly think that's going to work. It's just totally impractical, and the health services cannot provide the resources. For example, if the boat suddenly gets infected, or as these big boats do, suddenly an infection rages through, they simply wouldn't be able to cope. These are the sort of questions that should have been asked before the decision was made to put this boat or barge in the port.
Well, perhaps I can answer some of those questions, because we do have answers and did think carefully about each of those questions prior to making the decision to proceed with the policy and to apply it to his constituency. With respect to healthcare, we have worked with the UK Health Security Agency and taken their advice to ensure that no infectious diseases can spread on the barge, or where they do, appropriate steps are taken. He referenced the decision to provide basic primary care on or adjacent to the barge. That was not done, as he suggests, to privilege the migrants residing on the barge. Quite the opposite. It was done to ensure that those migrants placed as little burden as possible on local public services, so that it was not regularly necessary for the migrants to register with GPs or to take the appointments at GP surgeries that his constituents rightly demand. Given that the cohort of individuals will be relatively young, it's unlikely that they will place significant pressure on the local NHS, but we are working with them and the local Integrated Care Board to work through those challenges. He asked about the regime on the boat, and that is designed, again, to ensure there is as little issues for the local community as is possible within the confines of the current law, which is that the vessel has to be a non-detained one. That means that we will implement a regime which encourages very strongly the migrants to return to the vessel for 11 p.m. in the evening, and not, as he suggests, to roam the streets of the area. That there will be a secure cordon around the vessel, which again discourages people from walking into the community. That there will be a bus that takes the migrants to agreed places where they might spend some free time or go to a shop, again to discourage them from making journeys throughout the community and to carefully control their movements as far as one can within the limits of the law. He asked about the Ministry of Defence, and we have worked with them and sought their advice before proceeding, and to have considered the particular sensitivities of Portland Port. He asked about the police. We do want to work closely with them, and we have made clear that we'll provide a special grant to Dorset Police that will cover the additional burden that this special national endeavour has upon their very limited resources, because obviously we want to ensure that the local community is reassured as much as is possible, and that means that there will be extra neighbourhood policing and further support for the police, which is not coming out of the coffers of the local constabulary. With respect to Dorset Council, again, we've offered significant funding to them. They will receive at least £3,000 per asylum seeker residing on the vessel per year, which will enable them to provide extra resources and personnel to manage the project, albeit that we won't be placing many burdens upon them, as the vessel will be managed by the Home Office and its suppliers, and wherever possible we will pay for the services that are required for those individuals. And so a significant proportion of that funding, which, as I say, will run to millions of pounds, will be available to Dorset Council for whatever it wishes, and one would hope that they will choose to devote the lion's share of that to the needs and desires of the immediate population who are going to be most affected by this project. Be pleased to.
I'm very grateful, John. Could the Minister just confirm that this Stockholm biddy, I guess what it's called, it's designed for 222, that's what it says on the internet. It's going to have 506. How is the barge going to be refurbished to accommodate these young men, and in what how many rooms will be in 4s or 6s or 2s to accommodate this huge number?
Well, I'm not sure of the reference to which he's referring, but we won't be putting more migrants on the vessel than it is safe and appropriate to do. I do know that barges of this kind can either accommodate one individual per room or 2 in many cases, and so that may be the explanation that in some circumstances those organisations making use of this barge, such as construction companies, offshore oil and gas businesses, might choose to put one individual per room, but the barge itself can comfortably accommodate 2 or more. We will obviously abide by the relevant laws in this space to ensure that the migrants are properly accommodated, but also, to his point, as importantly, that we minimise the potential for there to be disturbances on the boat which will impact his constituents, the local police and community. In each of the actions that we're taking, though he may not appreciate this, the choices that we're making are guided by how we can reduce the impact of this barge on the local community. And if he or the stakeholders with whom we're engaging can think of further steps that we can take, we will obviously consider those and try to ensure that we do them wherever possible, unless there's a very good reason not to. I'm pleased to give way.
I'm very grateful to my right honourable friend for giving way. He will know that my neighbouring constituency of West Dorset is in many ways, although not entirely, equally affected, as indeed it is the constituency of my honourable friend and neighbour for South Dorset. I've been grateful of the brief dialogue that we've had, or I've had, with civil servants previously a couple of weeks ago, but on these points he's outlining, I am very keen to understand the risk assessments that have taken place in order to inform these points of which he's making. I've been asking for those for a couple of weeks, and I'd be grateful if he might confirm when indeed they would be available and presented to both my honourable friend and neighbour for South Dorset and myself.
Well, I know that the honourable gentleman met with my officials in the department, and I apologise I wasn't able to meet with them at the same time because I was attending a COBRA meeting with respect to the Border Force presence in Sudan this week. But I think we are meeting again soon, so that both myself and officials can discuss those points with him. We have considered the challenges and would be pleased to answer as many questions as we can. I see that there's only a very short period left, so if I draw my remarks to a close by saying that we all appreciate that whilst this policy is undoubtedly in the national interest, it has a particularly serious impact upon the community which the honourable gentleman represent. Myself, the Home Secretary, the government stand ready to work with them to make this policy as successful as possible, to listen to the views of their constituents and to mitigate the negatives as far as possible. He has our assurance that we will also, of course, do everything we can to stop the boats and to stop this problem at source.
The question is that this House do now adjourn. May I let me say aye? Aye. Contrary, no. I think the ayes have it. The ayes have it. Order. Order.